Got it. Good morning, everyone. I almost said good evening. Must have been one of those weekends. Welcome to the championship round of the 2023 Empire World Championship. We have two phenomenal teams whose identities I cannot reveal. I know both of you have experience competing in championship rounds. I hope regardless of what happens today, you can enjoy this experience and realize that we started with 425 students. Think about how crazy that is. 425 students in 5 countries in 20 states, 6 state champions, 2 national champions. Here we are, just 2 teams remaining. Enjoy this moment, appreciate this moment. Have a great trial. Let's bring in our judges. All rise. The court now in session. The Honorable Judge Danielle Roberts is presiding. Can I bring in the jury, Judge Roberts?
You may.
Wonderful. Okay, very good.
Well, maybe seated. Good morning, everyone.
Good morning. Good morning.
I am Judge Roberts. I will be presiding over your court hearing today. And I am going to call into order the case of Justice Carbo versus Shooting Star Gun Club LLC. This is case number 2023 CV002023. And the first order of business is the court will hear argument on the outstanding motion in limine regarding the claim under the Responsible Firearms Sales Practices Act. Are you ready to begin on behalf of Justice Carbo?
Yes, Your Honor.
All right. And will you, with regard to the Shooting Star Gun Club, will you please stand and state your appearance at this time?
Good morning, Your Honor. My name is Jenna Ahuja. I'll be arguing the pretrial motion on behalf of the defense. Lindsay Godia on behalf of Justice Carbo.
All right. You all may be seated. I'm going to briefly remind the parties of the procedure that this argument is going to follow. The parties are each going to have 8 minutes to present argument with the possibility of an additional 2 minutes of courtesy time if necessary. The court will consider that at its discretion, okay? Each counsel will have 45 seconds to present your argument without interruption. After that 45-second time period, Then the court, if I have questions, will direct those to the counsel arguing the case, all right? With regard to the counsel for Carbo, you're going to argue first because you are the moving party. And the jury is constructively absent for this argument, so counsel should address your arguments directly to the court. Do I have timekeepers for Carbo? Team Carbo?
Yes, Your Honor.
All right. And are you ready to proceed on behalf of Team Carbo?
Yes, Your Honor.
Do I have timekeepers for Shooting Star?
Yes, Your Honor.
And you're ready to proceed on behalf of Shooting Star?
Yes, Your Honor.
Thank you so much. All right, when the first 45 seconds is up after each side's argument, if both of you all would please stand and prominently display your time cards. I don't want you to shout out the time, but if you'll just hold that up and let me know that that 45 seconds has elapsed, and that would be greatly appreciated. Okay?
Yes, Your
Now, when time expires for the main argument, then you're gonna stand and say out loud the word stop so that I know that time has expired. Can you all do that?
Yes, Your Honor.
Abide by those rules. Thank you so much. You may be seated. I may permit courtesy time if it is necessary for each side, up to 2 minutes, but no more than 2 minutes. Immediately upon the expiration of any courtesy time, then you are required to stand, timekeepers and call out the time, okay? Counsel for Carbo, you may reserve up to 3 minutes for rebuttal and fixing statute. How much time, if any, would you like to reserve for me?
2 minutes, Your Honor.
All right, counsel, you've reserved 2 minutes for your rebuttal. Timekeepers, if you'll please stand and notify the court after 6 minutes, and that will leave those 2 minutes for counsel's rebuttal.
Yes, Your Honor.
All right. Any questions from my timekeepers with regard to the time requirements and rules?
No, Your Honor. No, Your Honor.
Thank you so much. All right, if there's nothing further from Team Carbo or Shooting Star, then we will begin our pretrial argument at this time. Counsel for Carbo, you may proceed.
Gogia on behalf of Justice Carbo. May it please the court. The plaintiff asks for your honor to grant our motion in limine and allow our claim under the Responsible Firearms Sales Practices Act to proceed. In this case, we argue that the defendant's entrustment of a firearm to Drew Cantrell on May 28, 2022 violated the RFSBA because he was unfit to teach a firearm safety course. The defense challenged the constitutionality of this statute and filed an affirmative defense against our claim. Today, we'll show you that the RFSBA is constitutional for 2 reasons. First, the situation in this as-applied challenge falls outside of the scope of the Second Amendment. And second, because even if you were to find that the situation in statute do apply, there's a historical analog, making it constitutional. First, the situation falls outside of the scope of the Second Amendment. According to District of Columbia v. Heller, the Second Amendment applies to the rights of individuals. I wanted to make it clear, Your Honor, we're not talking about individual rights.
But you would agree with me that although the Second Amendment applies to individual rights to bear arms, that the government does have an interest in regulating the ability of certain individuals to carry arms in public, correct?
Right, Your Honor. Drew Cantrell, in this case, he does have Second Amendment rights to keep and bear arms. He can keep arms in his house and leave his house with arms. Those aren't the rights we're talking about. We're talking about the right of a firearm safety instructor to teach a firearm safety course.
And wouldn't that be a good situation to apply an act like this, where we want to make sure that those that we've entrusted with the firearm can handle that firearm in a safe manner?
Exactly, Your Honor. That's what the RFSBA is doing in this case. It's regulating a firearm instructor to make sure that they are competent to teach a firearm safety course.
Mm-hmm.
And this is the same way that we regulate all teachers. A kindergarten teacher has to have a license to teach young kids what 2 + 2 equals. In the same way, a firearm instructor has to have reasonable restrictions in order to prove that they are competent to teach a firearm safety course. And that's all the RFSBA is in today's case. Your Honor, let's say a firearm safety teacher wasn't competent to teach a firearm safety course. that would prove dangerous and a threat to public safety. And that's why the RFSBA is so important. Secondly, Your Honor, even if you were to find that the situation and statute do apply, there's a historical plan, making it constitutional. According to New York State Rifle and Pistol Association v. Bruin, we do not need to identify a law from the past that is exactly the same as the current act. What does need to be identified, however, is a well-established historical analog. And, Your Honor, we can prove this analog. The RFSBA is relevantly similar to the surety statutes that are found in the mid-19th century. Under these statutes, in order to be entrusted a weapon, you have to first post a bond. And you don't receive that money back unless you are safe with that firearm.
Counsel, do you believe that those historical statutes took into account the firearms that we're speaking of in 2003 in today's day and age?
No, Your Honor, but that's why, because under Bruin, we do not need to identify a law from the past that is exactly the same. And the surety statutes are directly parallel to the RFSBA because they both create a financial penalty for being unsafe with firearms.
And you believe that it was appropriately applied in this case?
Yes, Your Honor. If a firearms safety instructor were incompetent, that would essentially restrict the rights of normal individual citizens to keep and bear arms. Take this case, for example. Drew Cantrell was an incompetent firearms safety instructor. He was the teacher of Justice Carbo. He was employed to safely teach Justice Carbo how to use that firearm. During that lesson, Justice Carbo was shot. And now you can ask her herself. Justice Carbo wants nothing else to do with firearms. So this incompetent teacher has essentially restricted her right to keep and bear arms. We ask that you grant this motion and allow our claim to proceed. Thank you, Your Honor.
Thank you so much.
Response from the defense?
Yes, the counsel, the shooting star, you may proceed at this time.
Good morning, Your Honor. Jenna Ahuja for the defense. Justice Scalia said in District of Columbia v. Heller that, quote, a constitutional guarantee subject to future judges' assessments of usefulness is no constitutional guarantee at all. At issue today is the Responsible Firearms Sales Practices Act, a law which violates the constitutional guarantee to keep and bear arms afforded to individuals in the text of the Second Amendment. The law permits sellers of firearms to subjectively decide who they think is fit or unfit to carry a weapon. We oppose the plaintiff's motion and ask you to find the act in violation of the Second Amendment for two reasons. First, the Second Amendment does cover the conduct that the act prohibits. And second, the plaintiff has not shown that this law is in line with our nation's historical tradition regarding firearms regulations.
Counsel, haven't we historically regulated the possession of firearms in this country?
Yes, Your Honor, and the court in Heller and Bruin found that restrictions on the sale of firearms are allowed if they're reasonable. But Bruin found that reasonable restrictions on the selling of firearms must be narrow, objective, and definite. Your Honor, the act in this case is entirely based on the subjectivity of the retailer. Therefore, it is a restriction, but it's not a reasonable one.
You don't think that it would be reasonable to regulate the possession of firearms by individuals who are required to teach firearm use and safety to other individuals?
Of course, Your Honor, and whether or not Drew Cantrell was actually fit to own a firearm is something that you'll decide in trial today if the plaintiff's motion is granted. Your Honor, the plaintiff actually misunderstood our as-applied challenge. They said, and I wrote it down, that we're talking about the right of a firearms safety instructor to teach a firearms safety course. But Your Honor, our challenge is not on behalf of Drew Cantrell. It's on behalf of Shooting Star Gun Club. It's my contention that my client, Shooting Star Gun Club, has a right to sell under the Second Amendment. And in this case, that right to sell was violated. because the plaintiff is seeking to hold my client liable for selling to somebody through Cantrell who was certified with the government in firearm safety and therefore very clearly fit to own this firearm. Your Honor, the plaintiff will contend that because the word sell does not appear in the Second Amendment, that the right to sell is not protected. But the amendment has two parts: the listed right, the right to buy arms, or to bear arms, and the right that supplies it, the right to sell them. Take the Fifth Amendment right to trial by jury, for example. While the Constitution never explicitly provides law-abiding individuals with the right to be eligible for jury duty, that right goes hand in hand with, it supplies, the right to a trial by jury, which is written in the Constitution. We see the same thing in this case with the selling and bearing of arms. One right cannot exist without the other. And because the Second Amendment protects the right of the people to keep, bear, buy, and sell arms, it applies to the act at issue today. Which brings me to my second point. The plaintiff has not met their burden to affirmatively prove that this act is in line with our nation's historical tradition. The plaintiff cited the surety statutes, laws passed in 10 United States jurisdictions in the 1800s. They claim that this is similar to those, but Your Honor, I'd like to make a distinction here. Under the surety statutes, the government enabled any third party to file a complaint with the court if they had a reasonable belief that somebody would breach the peace of the firearm. Only after that, the court found that complaint reasonable, then the defendant would be required to post bond in order to continue carrying that firearm. But Your Honor, before they posted that bond, they had the right to appeal, and they were only required to post that bond for up to 6 months. Your Honor, in our case, there's no bond posted. The gun is simply taken away from the individual before anybody even reasonably shows that they would be unsafe with that firearm.
And counsel, let me ask you, you don't believe that under this statute, there is any criteria for which Shooting Star would have been able to evaluate whether or not their employee was fit to hold a firearm or possess a firearm?
While the standards in this case do go to whether or not the employee would have been fit with a firearm, it's the subjective nature of these standards that we have an issue with. It's not necessarily the standards, but the way that they're applied, because it asks sellers of firearms to become quasi-judicial officials to determine whether somebody is fit to own a firearm, asking them to apply a broad totality of the circumstances standard that they're not trained in. But additionally, Your Honor, the government reserves the right to subjectively decide whether the seller subjectively applied a subjective standard correctly, and then they punish them if they don't like their decision. Under the Act, the government can take away a seller's retail license for up to 6 months or seize any firearms sold in violation of the Act. Your Honor, that's direct government infringement on both the seller and the buyer's Second Amendment rights. In Bruin, the law at issue is what we call a may-issue licensing law, a law which grants authorities discretion to deny concealed carry licenses to applicants based on whether they believe the applicant has demonstrated cause or sustainability for them. Only 6 states operate with these types of laws, and the court frowns upon them. 43 states operate with what we call shall issue laws that require authorities to issue licenses to applicants who satisfy threshold requirements, regardless of their personal opinion. The court in Bruin found that because these shall issue laws contain, quote, only narrow, objective, and definite standards guiding licensing officials, rather than the exercise of judgment and the formation of an opinion, that they don't prevent law-abiding, responsible citizens from obtaining firearms.
And I want to make sure that I'm following your argument, though. Those cases are specifically talking about an individual's right to bear arms under the Second Amendment. And what you're arguing is that Shooting Star had some kind of constitutional right to sell. Is that correct?
Yes, Your Honor, there's 2 issues in this case. Whether the Second Amendment applies, which is our contention that it does because of the right to sell. And once we decide that the Second Amendment applies, we just have to look at whether there's a historical analog. Not specifically whose rights were violated, just the nature of the law. And the way determining a historical analog is how and why it burdens somebody's Second Amendment rights. And so that's what we're looking at. Additionally, Your Honor, the plaintiff contends that the purpose of this act is to prevent people who might carry arms in a dangerous manner from owning them in the first place. In the antebellum America case of Simpson v. State, the court found that existing common law, reflected in the Statute of Northampton, did not permit the mere carrying of arms to be classified as a terror to the people. State v. Huntley tells us that carrying is only a crime if you do it for a wicked purpose or mischievous result. The key here is that all of these laws focus on some sort of malicious or reckless act with a firearm, not merely carrying or intending to carry. Your Honor, the act in this case asks sellers to look at a buyer's intent and subjectively decide whether they think in the future they will be unsafe with that firearm. And Your Honor, that's not something that's in line with our historical tradition. I see my time is expiring. May I briefly conclude?
You may, very briefly.
Your Honor, the Constitution cannot be optional. It's for these reasons that we respectfully request that you deny the plaintiff's motion and exclude the Responsible Firearms Sales Practices Act from trial today. Thank you.
Thank you so much. I am ready to hear rebuttal from Counsel Carbo, and you have reserved 2 minutes.
Yes. Your Honor, as the moving party, we are able to determine what the RFSBA is being applied to in today's case. And today we're applying it to the entrustment to a firearm safety instructor, not the selling of a firearm to Justice Carlo, as Attorney Apuja suggests. Because we're talking about the entrustment and Drew Cantrell's personal individual right to teach firearm safety, that is outside the scope of the Second Amendment. Attorney Apuja also mentioned that this law has to have narrow, objective, and definite standards. Your Honor, under Justice Kavanaugh's opinion, that is about may issue concealed carry license laws under the Second Amendment. That's not what we have today. The RFSBA in this as-applied challenge falls outside the scope of the Second Amendment and therefore does not have to have those narrow, objective, and definite standards. She also compared the RFSBA to may issue law licensing laws. Those require a government entity with the power to issue a license. That's not what we have here today. So it does not need to meet those standards. We ask that you grant our motion and allow our claim to proceed. Thank you.
Thank you so much. All right, I appreciate the argument and hard work of both parties. Both attorneys were very well prepared for the argument. I'm going to take just a few moments before I rule. That's going to be no more than 3 minutes. Timekeepers, if you will help me keep my time and hold me accountable. During that time, please remain in the room. Remember that you are only allowed to speak amongst yourselves with your teammates there at the table. Timekeepers, if you'll please start the clock at this time and announce when 3 minutes has passed.
Yes, Your Honor.
All right. Again, I thank counsel for their argument. I am ready to rule on the motion at this time. You all may remain seated. Based on the argument presented today, I am going to deny the motion in limine to allow the claim. I find that the conduct at issue in this case is sufficiently covered by the Second Amendment, which is the employee's right to keep and bear arms, and whether or not he is fit to keep and bear arms. I do think that it is a subjective standard. I don't believe that the Shooting Star Club should be able to make the determination as to whether or not a individual or an employee has subjectively violated a statute or committed conduct or engaged in conduct that would prevent him from bearing arms under the Second Amendment. I do believe that there is a historical analog, but I don't believe that the as applied standard is sufficiently applied or correctly applied in this case. So I am going to deny the motion. And since the court has denied that motion, Justice Carbo's second cause of action is dismissed with prejudice that will not proceed in the trial today. Additionally, Exhibits 16, 17, and 18 are excluded from evidence under Imperial Evidence Ordinance 402. This concludes the pretrial argument. The court is ready to move forward with the trial if there's nothing further from either party. Are you ready on behalf of Mr. Carbo?
Your Honor, just some brief housekeeping issues before we get into opening statements.
All right.
Your Honor, first, may we make appearances?
Yes, you may. You can go ahead and do that at this time, starting with Plaintiff.
Good morning, Your Honor. My name is Karthik Ratina Sabavati. Today I'm joined by my co-counsel, Michael DeVoe.
Good morning, Your Honor.
Good morning.
And Lindsay Godier.
Good morning, Your Honor.
Good morning.
On behalf of Justice Carbo, Your Honor.
Thank you so much. Let me have introductions from the defendant.
Yes, Your Honor. Good morning, Your Honor. My name is Grace DeVico, counsel for the defendant, Shooting Star Gun Club. May my co-counsel introduce themselves?
Please.
Good morning, Your Honor.
Good morning.
Adrian Flores.
Good morning, Your Honor.
Kate Brody.
Good morning.
Good morning, Your Honor. Jenna Ahuja.
Good morning.
Your Honor, may I invite your attention to our timekeeper? Good morning, Your Honor. Fiona Martinez.
Good morning, and let me go ahead and allow the timekeeper for Justice Carbo to introduce herself at this time as well.
Good morning, Your Honor. Sanaya King.
Are there any other housekeeping matters on behalf of Justice Carbo?
Yes, Your Honor. Since we've never been in your courtroom before, we'd like to ask for some preferences. When approaching opposing counsel, opposing witnesses, the bench, and the members of the jury, would you like us to ask permission first, or simply let the record reflect?
All right. Counsel for both parties are free to move around the courtroom as you see fit, and that includes the well of the courtroom. I would like for you to ask permission prior to approaching the bench, but not prior to approaching the bench.
Yes, Your Honor. And when making objections in your courtroom, would you like us to object and wait for your acknowledgement, or object and immediately state our basis?
I would like for you to object and immediately state your basis.
Yes, Your Honor. We'd also like the court to recognize that our timekeeper is one of our witnesses today. So during one of our direct examinations, we will have another witness step in place.
And may I know, can you tell me which witness that is?
Yes, Your Honor. The witness is Dr. Morgan Judd, the expert in today's case, and she will be switching out with Ms. Ross Hernandez, the character witness in today's case.
Okay, thank you for letting me know that.
And Your Honor, we also provided an exhibit booklet for the convenience of the witness stand. May we show it to opposing counsel and place it on the witness stand?
Yes, you may. Any objection to that?
No, Your Honor.
Go ahead and share that with opposing counsel.
And lastly, Your Honor, we've signed a character form that both parties have agreed to, and you have to tender it to the bench.
You may do that at this time.
Yes, Your Honor.
And you shared this with opposing counsel?
Yes, Your Honor.
Thank you so much.
Of course, Your Honor.
And Your Honor, with that, the plaintiff's ready to proceed into opening statements.
Thank you. Let me hear from defendant Shooting Star. Do you have any housekeeping matters at this time?
Yes, Your Honor. We would like to invoke Rule 615, which states that all witnesses are constructively excluded from trial, with an exception for party representatives if the plaintiff has one.
Any objection?
No objection, Your Honor. We'd also like to nominate Justice Carbo as our party representative.
That request is granted.
Yes, Your Honor, and today we will be using some blown up exhibits. We just ask if, when those exhibits are entered, are they constructively published to the jury, or would you like us to ask if we could publish them to the jury?
I'd like for you to request permission to publish those exhibits to the jury.
Yes, Your Honor. With that, the defense is ready to proceed.
All right, thank you so much. right, counsel for Justice Carbo, you may begin your opening statement at this time.
Yes, Your Honor. Michael DeVoe, on behalf of Justice Carbo, may it please the court. They put a gun in the wrong hand. Justice Carbo is looking for a firearm. She hasn't felt very safe and needs to protect herself. So she goes to the Shooting Star for an all-in-one experience. To buy a gun and learn how to use it. When she opens the door to the Shooting Star, she explains that she's never used a gun before. So she attends her first training class with someone she thought was a firearms expert, Drew Cantrell. She follows Mr. Cantrell to the gun range and listens to every word he says. Where to stand, what to wear, how to hold the gun. Miss Carbo's only new, after all. Mr. Cantrell raises his arms, gun in hand. Miss Carbo was expecting for his shot to hit the target. But the evidence will show that shot veered to the side. Before she could blink, another shot rang out. You'll hear that second shot landed in her leg. That's why we brought a claim of negligent hiring, supervision, or retention of an employee against the Shooting Star Gun Club. That means, in short, we have to show you three simple elements. Drew Cantrell was incompetent. The Shooting Star knew that. And Drew Cantrell's incompetence was a cause of Miss Carbo's injury. Now, we have something called the burden of proof. We have to prove by the preponderance of the evidence each of those three things I just told you. By the preponderance of the evidence simply means more likely true than not. And to meet that burden, we're going to ask you to focus on 3 points in today's trial. First, Drew Cantrell should have never had a gun in his hands. Next, the Shooting Star did nothing to fix that. And finally, they put a gun in his hands anyway. Now, to prove those 3 points, we're also going to call 3 witnesses to the stand. First, we'll call Miss Carbo herself. She's going to tell you about her experience with the Shooting Star, why she ever wanted to go there in the first place. And then you'll learn what happens when the Shooting Star puts a gun into Drew Cantrell's hands. Next, we'll call Dr. Morgan Judd. She's going to explain to you that Drew Cantrell violated the best practices of her field, violated the best practices of firearm safety. She's going to tell you that Mr. Cantrell mishandled the gun. That if he hadn't mishandled that gun, Miss Carbo wouldn't have been shot. And finally, we'll call Ross Hernandez, someone who frequents the Shooting Star. She's going to tell you this isn't the first time she's seen Drew Cantrell risk someone's life before. That she knows of 2 previous times where Drew Cantrell risked someone's lives because a gun was in his hands. Well, that's why, at the end of today's trial, my co-counsel, Karthik Rathinasabhavathy, is going to come before you. He's going to tell you that we have met our burden beyond anything the defense tries to show you today. And he's going to ask you to find the shooting star gun club. Why? Because then, put a gun in the wrong hands. Thank you.
Thank you. If you'll give us just a moment before you begin on behalf of Shooting Star. We are ready for openings on behalf of Shooting Star. You may begin at this time.
Yes, Your Honor. May it please the court. This is a case about a faulty trigger and faulty logic. Today, we're not going to ask you to disregard the entire story the plaintiff just told you. Instead, we want to help you fill in the gaps. Now, we'll do that by asking some very important questions. Questions like, could the gun have been defective? Was Justice Carbo standing where she was supposed to be standing? Whatever the plaintiff's logic was, it did not lead them to these questions. But we trust that as you listen to today's testimony, you will take these questions more seriously. When you do, you'll find that this case is not about Shooting Star's negligence. This is a case about a faulty trigger and faulty logic. The plaintiff has brought a claim of negligent hiring against the Shooting Star gun club. We are bringing what's called an affirmative defense of an intervening and superseding cause. Now, what that means is that we are going to show you there was an intervening cause for Justice Carbo's injury on May 28th. The two things happened, in fact, that superseded or went beyond anything my client could have reasonably anticipated. We'll prove that to you by a preponderance of the evidence, that it's more likely than not what happened. The plaintiff is going to have to meet that same burden to prove my client's negligence, but they'll fail for two reasons: their own faulty logic and the gun's faulty trigger. First, what you'll hear from our witnesses will demonstrate that the plaintiff's logic simply is not sound. Safety instructor Drew Cantrell himself will take the stand. He'll explain to you that what the plaintiff claims is evidence he should have been fired is really just two isolated instances over a period of years, neither of which were ever repeated. But by the plaintiff's logic, that should have been enough for him to instantly lose his job. Now, as for the actual incident, Avery Wynn will take the stand to corroborate Drew Cantrell's account. Both of them will confirm that the plaintiff disobeyed direct instructions and moved to stand right next to Drew Cantrell. You'll see the bloodstains on the ground to confirm exactly where she was standing. The plaintiff will tie themselves into knots trying to explain how Justice Carbo could possibly have remained in one place, how she possibly could have made contact with Drew Cantrell while somehow remaining behind him. But you'll see that their claims simply do not pass logical scrutiny. But most importantly, members of the jury, you'll hear from Jack Stubb, an expert in firearms mechanics and firearms safety. He performed an analysis of the actual gun that shot Justice Carbo. He'll explain to you that the trigger on that gun was faulty, that it was overly sensitive and could have been pulled with hardly any pressure.
will explain exactly how this led to the plaintiff's injury due to no fault of anyone else's. Now, at the end of trial, the plaintiff is going to have to ask you to disregard these findings today, to accept their logic at face value. We'll ask you to see through that attempt, to remember what this case is about. A faulty trigger and faulty logic. At the end of trial, we'll ask you to find the Shooting Star Gun Club not liable. Thank you.
All right, Carbo, you may present your case. As per special instructions, you are required to call Justice Carbo as your first witness. Are you ready to begin?
Yes, Your Honor.
You may do so at this time.
The plaintiff calls Justice Carbo to the stand. May I proceed?
You may.
Good morning.
Good morning.
Could you please introduce yourself to the members of the jury?
Good morning. My name is Justice Carter.
Where are you from, Ms. Carbo?
I've always lived in Imperial State. Ever since I was little, my whole family's from there. My mom, my dad, really my home.
What do you do for a living here in Imperial State?
I'm actually the lead manager of the Imperial State Library. We have the largest collection of books in the country. I mostly help, kids reach books from high shelves, people checking out books, that kind of thing.
I want to get right into the facts of today's case. Why are you here in court today?
I'm here because of what happened to me at Shooting Star.
What happened to you at the Shooting Star Gun Club, man? Let's take a few steps back. What is the Shooting Star Gun Club?
When I first looked into it, I thought it'd be a place where I could buy a gun that was best for my needs. I could learn how to protect myself. Clearly I was wrong.
Why did you ever want to protect yourself in the first place?
Unfortunately, around the time I went to Shooting Star last year, there were a lot of break-ins in my neighborhood. Someone tried to rob me on my way home from work. They tried to steal my books.
Let's talk about your experience with the Shooting Star. How'd you first contact the Shooting Star?
I first contacted the owner, Skylar Coleman, over email.
Ms. Carbo, how'd you go from emailing the owner to being shocked, ma'am?
Unfortunately, I was pretty disappointed with the way me and Ms. Coleman were having conversations over email. I wasn't really feeling like my questions were getting answered. So I ended up having to go in person to Shooting Star Gun Club.
How many times did you go in person to the Shooting Star Gun Club?
I went twice. Once around May 20th of last year, and then again on May 20th.
Let's talk about that second time you went. Did you buy a gun that day?
Yes, I bought a gun.
Did you receive any firearm training after purchasing that gun?
Yes, after asking for a firearm safety course, I was provided one by Shooting.
Who trained you?
I was an employee.
Talk about you saw Mr. Cantrell with a gun in his hands. Ms. Carbo, could you walk the members of the jury through that training?
Yes.
Drew Cantrell to the gun range, I believe it was Scoop 11. There was another person there, I remember Nick Allred. Drew Cantrell, who was briefly on that gun safety.
Did anything happen after Drew Cantrell taught you that gun safety?
Well, he told us that he's showing us how to properly fire the gun, but using the gun that I just purchased. And pointed that gun at the range.
And what happened after Mr. Cantrell pointed that gun downrange?
I heard one shot go somewhere in the range, and then I just looked at me.
Where did that second shot land, Miss Carbo?
The shot, my leg went completely numb. My leg is weak.
Miss Carbo, during the entirety of that training, did you ever jump from any loud sounds like a gunshot?
No, actually, offered me and Nick Allred earmuffs, so someone was pretty much from the gunshot.
During the entirety of that training, did you ever see Drew Cantrell load the weapon?
No, I never saw him load that.
And during the entirety of that training, did you ever see Mr. Cantrell test fire that weapon?
No, before they demonstrated how to fire it, I never saw them try to test the gun.
Thank you for your time, Ms. Carbo. Nothing further at this time, y'all.
Just a moment before we begin. You may begin your cross-examination at this time.
Yes, Your Honor, before I proceed, I asked to set up an enlarged copy of an exhibit. It'll be turned around.
You may do so at this time.
May I proceed?
You may begin when you're ready.
Good morning, Ms. Carbo.
Good morning.
Now, in direct examination, you said, and I wrote it down, that Mr. Cantrell never tested that gun.
Before they told us that they were gonna fire the gun and teach us how to safely use it, I never saw them fire it before.
Ms. Carbo, you didn't add that in your deposition, did you?
Well, I said that Drew Cantrell, when they told Drew Cantrell fire the gun, was when they told us they were gonna safely demonstrate how to fire.
Ms. Carbo, you never added in your deposition that he never tested the gun, yes?
That's right, I never put any testing gun in the deposition because I didn't see a test.
So, Ms. Carbo, I need to ask you a few more questions about what happened on the day of your injury, May 28th of last year. Safety instructor Drew Cantrell started out by explaining the rules of gun safety.
That's right.
Then he prepared to show you how to fire the gun.
Yes, he did.
Ms. Carbo, I want to look closely at where both you and Mr. Cantrell were standing. Your Honor, approaching opposing counsel with Exhibit 2G. Approaching witness with the same. Ms. Carbo, you recognize this as a photograph of the shooting stall that Mr. Cantrell taught a safety course out of?
Yes, that's what it looks like.
The X's on this exhibit, they accurately mark where both you and Mr. Cantrell were standing?
That's right. The blue X looks like it's where Drew Cantrell is standing. The red X is where I was standing, and the yellow X is where Nick Allred was standing.
Your Honor, we move to admit Exhibit 2G into evidence.
Any objection?
Without objection, Your Honor.
Submit it without objection.
Your Honor, permission to turn around an enlarged copy of Exhibit 2G for the jury?
You may publish at this time.
So Ms. Carver, you can confirm that the red X in the middle is where Mr. Cantrell instructed you to stand, yes?
Yes, that's exactly where he instructed me to stand, and I stood that exactly there.
So Ms. Carbo, it's your testimony today that when Mr. Cantrell fired that first shot, you were still standing in this exact same position.
Absolutely.
You weren't standing any closer to Mr. Cantrell's position?
No, the only time I moved in that position.
Ms. Carbo, let's take a closer look at that. You'd say that when Mr. Cantrell fired that first shot, the gun was suddenly pointed at you.
The first shot was somewhere in the range, and then the gun was pointed at me.
And Ms. Carbo, when Mr. Cantrell fired that first shot, were you standing directly next to him?
I was standing right here on this red X.
So it's your testimony today. And when Mr. Cantrell fired that first shot, you were standing where he told you to stand next to and behind him, yes?
That's right. I was standing right where he told me to stand, to his right.
Ms. Carbo, what you're saying is that when Mr. Cantrell fired that first shot, his arm swung around so significantly, well past 90 degrees, that the gun was actually pointed behind him?
Well, when Mr. Cantrell fired the first shot, I actually saw him flinch a bit, and then, yes, the gun was pointed at me.
Ms. Carbo, you were standing next to and behind him, yes?
Yes, that's right.
All right, Ms. Carbo, I want to talk about what happened next. Something else happened right before that second shot was fired, right?
Yeah.
Isn't it true that you and Mr. Cantrell bumped into each other?
Yes, after I saw Mr. Cantrell flinch, he bumped into me.
Ms. Carbo, somehow you were standing so close to Mr. Cantrell that he was able to bump into you.
That's right. Drew Cantrell told me to stand directly to his right. I trusted him, so that's exactly where I stood.
Ms. Carbo, you were standing next to and behind him, yes?
Yes,
And it was only after the two of you made contact that the gun was pointed downward towards your leg.
that's right. Mr. Cantrell flinched, and he bumped into me. The gun was pointed at me.
And Ms. Carbo, regardless of who bumped into who, when you made contact with Mr. Cantrell, the second shot was fired, yes? Ms. Carbo, I want to talk about the real reason you're here today. You're trying to take every penny you can from Shooting Star, yes?
I went to Shooting Star Gun Club to buy a gun to protect myself, and I ended up getting shot. I want justice.
So Ms. Carbo, you're trying to take every penny you can from Shooting Star, yes?
What they did to me? Absolutely.
Thank you, Ms. Carbo. Your Honor, I have no further questions.
Redirect.
Yes, Your Honor. Ms. Carbo, I want to talk about this for a second. Why were you standing right here at this red X?
Exactly where Drew Cantrell told me to stand.
I want to clarify something for the members of the jury. Did you bump into Drew Cantrell, or did Drew Cantrell bump into you?
Mr. Cantrell flinched. He bumped into me.
Thank you for your time today, Ms. Carbo. Nothing further at this time, Your Honor.
Thank you. Any recross?
No recross, Your Honor.
Plaintiff may call its next witness.
Yes, Your Honor. Prior to doing so, we ask that Ms. Carbo be allowed to step down from the stand.
You may sit down at this time. Thank you so much for your testimony.
The plaintiff calls Dr. Morgan Judd to the stand. And Your Honor, a moment for our other witness to swap out for her. May I proceed?
You may do so.
Good morning.
Good morning.
Could you introduce yourself to the members of the jury?
Hello, my name is Dr. Morgan Judd.
What do you do for a living, Dr. Judd?
I'm currently an associate professor in the Center of Gun Violence Prevention at Imperial State University.
And ma'am, did you go to school before working at Imperial State?
I did. I earned my master's in statistics from Auburn University and went on to earn my PhD in public policy from Tulane University.
And have you been working at Imperial State your whole life?
Not exactly. I mean, I've had many jobs over the years. My most recent one being an intern in the United States Bureau of Alcohol, Tobacco, Firearms, and Explosives. I did that for about 2 years.
I want to talk more about that job, ma'am. Why did you leave the ATF?
2011, my niece is currently Defendant. It helped pivot my career into researching and advocating for them.
Ma'am, what's the difference between the work you do at Imperial State and the ATF?
Things much has changed other than the big fact that the ATF, I was able to help with gun violence from the field, and now at the university, I'm able to do that by lobbying and research.
And ma'am, do you have any certifications with firearms?
I do. I have my firearms safety certificate in.
So I want to talk more about why you're here in court today. Why'd you take this case on, Dr. Judd?
I was contacted by counsel to provide my opinion on the best practices for gun safety.
Dr. Judd, did you reach a conclusion based off the questions that was asked?
Yes.
Did you reach that conclusion to a reasonable degree of scientific certainty?
Yes,
Did you use reliable facts and methods when coming to that conclusion?
I did.
Dr. Judd, what evidence, if any, did you review when coming to your conclusion?
I reviewed exhibits 1 through 23, the affidavits of Nick Allred, Avery Lynn, and Drew Cantrell, as well as the depositions of Justice Carbo and Fred.
Your Honor, at this time, the plaintiff moves to tender Dr. Morgan Judd as an expert in firearm safety, as both parties have stipulated she's qualified under Rule 702, under stipulation 12.
Any objection?
No objections, Your Honor.
All right, this witness will be admitted as an expert in the field of firearm safety. You may continue.
So, Dr. Judd, I want to talk more about those questions we retained you to answer. Could you tell the members of the jury what they all were?
There were a total of 3. To identify and explain the best practices for gun safety, whether or not shooting star violated any of these best practices, and whether Drew Cantrell was safely entrusted with the problem on May 28, 2020.
So let's take those questions one at a time for the members of the jury, starting with that best practices. What are the best practices for gun safety?
There are a total of 5 best practices. Although through my time of work, I've learned that people learn better from show rather than tell.
Ma'am, how can you show the members of the jury the best practices of gun safety?
The talk that I would like to use today. Budget cuts have been a little tough at the university, so it doesn't see the gun, I will have to use the hair dryer.
Your Honor, permission for Dr. Judd to step down from the witness stand to use that hair dryer?
She may.
Dr. Judd, how are you going to use this hair dryer to demonstrate gun safety?
Well, what I want you to do is to hold out this hair dryer as if you were aiming to shoot. The first thing I want to point out is that you're aiming at someone else. One of the first basic safety rules I want to explain is that you should never point a firearm at someone else unless you intend to shoot them. So what we're going to do is we're going to move this hair dryer away from the next lady in the back. The next thing I want to point out is that you have your finger on the trigger, well, in this case, the on button. You never want to have your finger on the trigger unless you are ready to pull that fire.
Where should I put it, Dr. Judd?
You should always keep your finger along the long end of the barrel, or in this case, the long end of the hair dryer. Another thing I want to point out is that you always want to make sure your safety mechanism on the firearm is engaged. This hairdryer doesn't exactly have a safety mechanism, although if it were a firearm, you would most likely find it along either the barrel or somewhere in between the barrel and the handle of the fire.
And ma'am, are there any best practices you can't demonstrate with this hairdryer?
There are. So when you're not holding a firearm or you're not intending to aim it at someone, you always want to hold it towards your side, out of the way of shooting. And what I want to do is you always want to make sure of your target, which is why we moved it away from the knife blade. But you always want to make sure that you never. You want to. Sorry, my apologies. You always want to make sure that your firearm, or in this case, the hairdryer, is not loaded. The hairdryer is not plugged in this situation, and you always want to make sure you check your firearm to make sure it is unloaded, because you never.
Thank you for that demonstration, Dr. Judd. You can sit back down. So, Dr. Judd, how did those best practices of gun safety apply to the Shooting Star Gun Club?
I found that the Shooting Star Gun Club, and in particular, youth control, violated 3 of these best practices.
And what evidence did you review to find out they violated 3 of those best practices?
Found that out by the depositions and affidavits provided to me, as well as the agent.
And Dr. Judd, over what course of time did the Shooting Star violate these best practices?
It was over the time course of May 2021 until May 2022, with an event in the middle being November 2021.
So, Dr. Judd, let's walk through those incidents. What happened in May of 2021?
In May of 2021, Drew Cantrell pointed a firearm at another person. This breaks the basic gun safety rule of never pointing a firearm at someone else unless you intend to shoot them. And it also breaks another firearm safety rule of always being aware of your target and beyond.
Dr. Judd, I picked up something during opposing counsel's opening statement that you weren't here to listen to. I want to ask you right now. Was this an isolated incident, ma'am?
Objection, Your Honor. Speculation, maybe heard.
You may.
Your Honor, in this jurisdiction, this witness was not in trial during opening statement. Opposing counsel cannot ask her about information that was brought up during that statement.
Yes, Your Honor. I'm not asking about any specific fact that was brought up during defense counsel opening statement. I'm asking about a question which was inspired by that opening statement. She's not basing any of that testimony off of what Mr. Flores said, rather her own expertise and the evidence she reviewed.
You may close on your objection.
The specific statement that opposing counsel said was that in my co-counsel's opening statement, they said that it was an isolated incident, and then he asked her to respond to that. Your Honor, that's asking this witness to respond to testimony she wasn't here for, and she can't testify to.
I'm going to overrule the objection. You may continue.
Yes, Your Honor.
Was the instance in May of 2021 an isolated incident?
No, Drew Cantrell also violated this incident on May 28th, 2020.
So, Dr. Judd, I want to talk about those other mentions of breaking best practice. When was that second?
Second one was in November of 2021.
What happened then, ma'am?
Drew Cantrell exited the firing range with a loaded firearm.
And what best practice did this violate?
Always keep a gun unloaded unless in need.
And finally, I want to talk about that third incident in May of 2022. What happened then?
This was the event of the training session conducted by Drew Cantrell involving Justice Carter. On this incident, Drew Cantrell was mishandling firearms, which directly resulted in.
Dr. Judd, did you find anything else wrong with that training session other than the mishandling of that firearm?
Absolutely. I found that Drew Cantrell violated basic safety practices of never pulling the trigger unless you're ready to fire, and to always be aware of your target and beyond.
So I want to talk more about that mishandling. What do you mean by that exactly, Dr. Judd?
Based on 2 eyewitness reports, I found that Drew Cantrell flinched prior to the first shot.
Did you conclude anything on his grip of the firearm?
I did. I found that he also had a tight grip as he was trying to gain more control over the firearm.
Dr. Judd, why is that a problem?
When a gun is falling, you want to let it fall. Because trying to grip it as it's falling can lead to a pull of the trigger or malfunction in the gun that can cause another shot to the neck. Want to let the gun go so there's less of a chance that a gun can intercept.
Thank you for your time today, Dr. Judd. Your Honor, I have no further questions.
Thank you. One moment before you begin your cross. You may begin your cross-examination at this time.
Yes, Your Honor. Good morning, Doctor. Good morning. I'd like to start by talking about something you said on direct examination. You said that one of the rules of gun safety is to always be aware of your target and then beyond your target, right?
Yes, that's correct.
Do you believe that Drew Cantrell violated that rule in today's case?
I do, absolutely.
Let's talk about that. You'd agree that Justice Carbo was not near Drew Cantrell's target, right?
Yes, I'm aware.
And Drew Cantrell was looking at that target when he was about to shoot.
Prior to the first shot, yes.
So he knew his target and then beyond, right?
For the first shot, yes.
All right. You'd agree with me that while Drew Cantrell was aiming that gun, he wasn't looking behind him, right?
I don't have no evidence of that.
If Drew Cantrell was looking behind him while firing that shot, that would be a violation of best practices, right?
It would.
Because he wouldn't have known his target and beyond.
That's it.
All right, so let's talk about your conclusions. I read your report, and I was wondering if we could talk about those. So you concluded that you don't think Drew Cantrell should have been able to handle a firearm on May 28th, right?
Yes, that's correct.
Now, you believe that he had already, before May 20th, failed time and time again to abide by the most basic of firearm safety rules.
Absolutely.
By time and time again, Doctor, you meant 2 times, right?
Yes.
Let's talk about those times. That first time, it involved Drew Cantrell pointing a gun at someone, right?
It did, yes.
We can agree, that's a safety violation.
Absolutely.
But Drew Cantrell was reprimanded for this by Skylar Coleman, right?
With only a verbal reprimand. Like, I'll mark on his record.
There was also a physical, official write-up given to Drew Cantrell, right?
Yes.
Now, prior to this incident, you aren't aware of a single time when Drew Cantrell violated any gun safety rules.
Sorry, could you repeat your question?
Prior to this incident that we're talking about right now, you aren't aware of a single time when Drew Cantrell violated any gun safety rules.
No, I have no evidence.
And at that point, Mr. Cantrell had been handling firearms for over 10 years.
Recreation, not in a professional or proper sense.
He was still handling firearms, right?
Again, recreational.
I'm gonna need a yes or a no to my answer. He was handling firearms for over 10 years prior to that incident.
Yes.
Let's talk about that second incident. This involved Drew Cantrell bringing a loaded gun into the shop front, right?
Yes, that's correct.
He was again reprimanded for this by Skylar Coleman.
Verbally, yes, and another mark on his record.
And another official write-up, right, Doctor?
Objection. 1002 best evidence. May I be heard, Your Honor?
You may.
Your Honor, we have this written reprimand in court today. It'd be better for the members of the jury to see it itself rather through Mr. Vico's line of question.
Have you heard, Your Honor?
You may.
Your Honor, this witness learned about these incidents through other ways, such as depositions and affidavits. not just because of this exhibit. Therefore, she can testify to it. It's not best evidence. I'm also not disclosing contents, specific contents of this exhibit, such as actual phrasing on the exhibit.
You may close on your objection.
Yes, Your Honor, once again, we have this written reprimand in court today, and Ms. DeVico is asking questions about this written reprimand. If the members of the jury were to see this document itself, it would make it easier for the proceedings of today's trial.
Thank you so much for your objection. I'm gonna overrule that objection. You may continue.
Yes, Your Honor.
So there was another official write-up for that incident, right?
Yes, there was.
And after that reprimand and write-up, you aren't aware of a single time when Drew Cantrell repeated that violation.
No, not formally.
Not at all, right?
Yeah.
Let's talk about May 28th and your conclusions on that day. Now, you believe that Drew Cantrell should not have been able to teach that safety course.
No, I don't.
You first thought that Mr. Cantrell was unprepared to teach it.
Yes,
Now, you are aware that Mr. Cantrell had been teaching a safety course similar to that for almost a year at that point,
that's correct.
with no reported incidents during any of those classes, right?
No, however, but I don't think that has anything to do with preparation. I found no preparation on the training session on May 20th.
Doctor, I'm going to need you to answer my questions. I'm directing you back to my question. There was no reported incidents during any of those classes leading up to May 28th. Do I have that right?
Not that I,
Well, primarily, you focus on what caused that second shot that hit Justice.
yes,
You believe that Mr. Cantrell should not have flinched before firing that first shot.
yes, that's correct.
Now, you weren't there, doctor, right?
No.
So we can agree you're running under an assumption that Drew Cantrell did flinch.
Not exactly. I have two eyewitness reports that said that Drew Cantrell did flinch prior to the first shot.
Let's talk about those two reports. That first report is Nick Allred, right?
Yes, that's correct.
Mr. Allred wasn't even sure what he saw, right?
I believe Nick Mallard said that he saw some movement before Cantrell fired the first shot.
Well, he said he saw some movement, but he also said he was unsure about that movement, right?
I think he was unsure of what the movement was, not exactly.
Objection, hearsay under Rule 801.
It's fine.
Your Honor, this is an expert. I'm asking on the facts that she used in determining her conclusion. Under 705, that is allowed.
May I respond on those grounds, Your Honor?
Right.
Rule 705 works in a way where experts can rely on hearsay to come to their conclusion. However, under Rule 705, experts cannot act as a conduit to hearsay in order to get prior inadmissible statements of hearsay in. And that's exactly what Ms. DeVico is doing with this line of questioning. The probative value isn't substantially outweighed by the prejudicial value, and by entering the exact statement that Ms. Allred had in her affidavit is improper under Rule 705 and 801.
Maybe heard, Your Honor.
You may.
Your Honor, this witness concluded that Drew Cantrell flinched. I'm asking about what she relied that conclusion on, and she said it was two reports. Now I'm asking about the credibility or validity of those reports. That goes directly to this witness's conclusion. It is extremely probative in today's case.
You have anything further?
Yes, Your Honor, she can attack the credibility of those two reports through other means, but by bringing in the exact statement that Ms. Allred wrote in her affidavit, that is improper. It doesn't matter if the probative value outweighs that fact. It's still an out-of-court statement being taken for the truth of the matter asserted. It's still hearsay, despite what opposing counsel is trying to argue under Rule 705.
I'm gonna overrule your objection.
Yes, Your Honor.
So, Dr. Jen, the report that you relied on from Nick Allred said that he was unsure of the movement that he saw. Yes or no?
Yes,
And Justice Carbo is the plaintiff in today's case, right?
yes,
That was the second report you relied on?
that's correct.
All right, so Dr. Judd, and for the record, Your Honor, I'm holding up Exhibit 1. It's been pre-admitted under Stipulation 8. Did you examine this gun in today's case?
Yes, I did.
Doctor, you didn't include any findings about that examination of that gun in your report, did you?
I I did say that I examined the gun.
Well, I know you examined the gun. I'm talking about those findings, your analysis. You didn't include any of that in your report, right?
No, I did not.
Now, you're aware that Drew Cantrell reported the recoil on this gun, it was faulty, right?
For that Drew Cantrell said the recoil was unlike anything that he ever felt before.
All right, you have no way of confirming that in your report? Not sure what you're asking. You didn't include anything in your report about you testing that recoil.
No.
Well, are you familiar with the concept of a light trigger?
Somewhat.
Well, it's a trigger that can be easily pulled, right, doctor?
Yes.
You didn't mention anything in your report about you testing this gun's trigger, did you?
No, however, I'm no expert in firearm mechanics.
Well, that wasn't my question. My question was what you included in your report. You did not include in your report whether this gun's trigger was light.
No, I didn't. Then I'm no expert in firearm mechanics.
Now I'm going to need a yes or no to this question. You did not include anything in your report about whether this gun that was used in the incident was overly sensitive.
No.
Thank you. Your Honor, I have no further questions.
Is there any redirect?
Yes, Your Honor. Dr. Judd, I want to talk about those eyewitness reports you relied on. How many eyewitnesses did you have for today's case?
I had 4 eyewitnesses,
Could you tell the members of the jury who those 4 people were?
of course. Avery Lynn, Drew Cantrell, Justice Carbo, and Nick Allred.
And you mentioned on cross-examination, you relied on the eyewitness reports of Justice Carbo and Nick Allred. What about Avery Nguyen and Drew Cantrell, man?
In terms of Drew Cantrell, I'll start. Drew Cantrell is part of the defendant, and a part of the defendant's case today. I found that they had way too much bias in today's case of whether or not they flinched or not. In terms of Avery and Lynn, they were sitting 30 feet on the other side of the gun. Although they did not have an unobstructed view, they were in fact paying the most attention to what was happening.
Thank you for your time today, Dr. Judd. Your Honor, I have no further questions.
Any recross?
None, Your Honor.
Thank you so much. Dr. Judd, you may step down. Thank you for your testimony. Just one moment before you call your next witness.
Yes, Your Honor.
Plaintiff may call its next witness.
The plaintiff calls Ms. Ross Hernandez. Good afternoon.
Good afternoon.
Could you please introduce yourself to the members of the jury?
Hello, everybody. My name is Ross Hernandez.
Where are you from?
I was born and raised right here in Imperial. I know this place so well. Thought I could tell you where to find the smoothest jazz club in the city.
What do you do for a living?
I run a local music store called the Hyde. At my store, we sell everything music related, and we even have a studio in the back. I run the music store by day, but at night, I'm DJ Roast Sandwich.
Let's talk about your business a little bit more. How long have you been running it?
I opened the High Note right after I graduated from high school, back in 2012. It's been what, 11 years now?
Where's the High Note located?
My store is in a strip mall with a bunch of other shops.
What are some of those other shops?
We have the Shooting Star Gun Club on the left, and Bozo's Clown Shop on the right.
Let's talk about that shop on the left. What is the Shooting Star?
The Shooting Star is a gun. It's got a range and even a bar. And they've always been wonderful names, unlike Bozo's Clown Shop. I mean, they just go honk, honk, honk. Rowdy clowns are enough to drive anyone crazy.
Ms. Hernandez, how often do you visit the Shooting Star Gun Club?
I go to the Shooting Star around 4 times. I never go there to use a gun, but I've been in the gun range multiple times. What I really go there for, though, is the fun. Trust me when I tell you, if you've heard some of the people who book studio sections at the High Note, you need a real stiff drink too.
You know the owner of the Shooting Star Gun Club?
Yeah, I do. Sky and I were really good friends. She helped me out a few years ago, and ever since then, we've been incredibly close.
So are you incredibly close with all of the employees at the Shooting Star Gun Club?
I try to get along with everyone at the Shooting Star. But there is this one guy that I can't get along with. That's Drew Cantrell.
Why can't you get along with Mr. Cantrell?
He's always seemed a bit smug to me. And I don't use guns, but I've been in the gun range multiple times, and I've seen the gun safety rules posted inside. And I know that Drew's been reprimanded for breaking those rules before. That's why I don't like it.
Let's talk about those gun safety rules you just mentioned. Could you flip to Exhibit 8 in that exhibit binder in front of you? What is this, Ms. Hernandez?
It's the list of gun safety rules posted inside the gun.
Is this a fair and accurate copy of those gun safety rules?
Yes, it is.
Your Honor, the plaintiff offers Exhibit 8 into evidence.
Any objection?
No objections, Your Honor.
Admit it without objection.
Perhaps have you heard of Mr. Cantrell breaking one of these rules?
Twice.
When was the first time?
The first time was in May of 2021.
What happened?
Drew was arguing with someone in the bar. They were yelling, screaming, and really causing a commotion. And mind you, Drew had a gun in his hand at the time.
Did you have that gun in his hand?
Yeah, the gun started out by his side, and then suddenly he raised it, pointing a gun at the person he was arguing with. The whole room was silent, except for the pin drop.
Mr. Hernandez, to your knowledge, was Mr. Cantrell punished for this?
Guy came in, broke the silence, really told Drew off. I mean, I don't think I've ever heard her yell that loud, ever.
You mentioned that Mr. Cantrell broke another gun safety rule. When was the second time?
The second time was 6 months later, in November of 2021.
What happened this time?
I went into the Shooting Star around lunchtime to tell Sky about the vacation that I was planning. My absolute favorite jazz band is having a show in New Orleans, and I really wanted to go see them.
When I walked into the shooting star, there was no one there. So I started to head towards Sky's back office door, which is where I know she is throughout the day. But as I got closer, I heard Sky yelling. And she was referring to the person she was yelling at as Drew.
Were you able to hear what Miss Coleman was yelling about?
Yeah. Sky was yelling at Drew for breaking another safety rule. And this time, Drew had left the gun range a loaded gun.
Thank you, Mr. Hernandez. Nothing further at this time, Your Honor.
Any cross?
Yes, Your Honor. Good morning, Mr. Hernandez.
Good morning.
I want to talk about the two incidents you just told us about in direct. But first, I want to be upfront with the jury. On direct examination, you said that you don't get along with Drew Cantrell, right?
We can't really get along with him, no.
In fact, you can't stand him.
Not really. I try to avoid him when I can.
And it's not just because you saw Mr. Cantrell break some safety rules, right?
No, I can't really get along with Drew.
Well, you don't even like his personality.
Not really.
We'll talk about the first incident you told us about. You told us that you saw Drew Cantrell point a gun at someone else, right?
That's right. I turned around, Drew's one arm was by his side, and then suddenly he was pointing a gun at somebody.
After this happened, Skylar Coleman started yelling at Drew Cantrell about not pointing guns at other people.
Guy came in and yelled really loudly.
Like you said on direct, you never heard him yell so loud.
Oh, my God.
You didn't see Mr. Coleman act like nothing had happened, right?
Can you repeat the question?
Mr. Hernandez, you didn't see Mr. Coleman act like nothing had happened.
Coleman was yelling at Drew to never point a gun at someone in the shop. So, no,
He talked to everyone in the shop, right?
that's right.
He told everyone to stay put.
That's not right, yeah.
Mr. Coleman said he wanted to keep the shop safe. Do I have that right?
That's what Scott said, yeah.
And then you saw Mr. Coleman lead Drew Cantrell into the back, right?
That's right.
They were gone for about 5 minutes.
Yeah.
And when they came back, Mr. Coleman even asked you what you had seen.
Coleman did, yeah.
And Mr. Hernandez, after this incident, you never saw Drew Cantrell point a gun at someone else again.
No, I didn't see Drew point a gun at someone else. Yeah.
I want to talk about the second incident you told us about. With this incident, you never actually saw anything Drew Cantrell did.
I didn't see anything. I heard Sky yelling at Drew about it.
That's right, you just overheard Skylar Coleman talking to Mr. Cantrell.
That's right.
It was something about leaving ammunition and a gun after leaving the shooting range.
Yeah.
But you weren't there during the incident they were discussing, right?
I wasn't there during the incident, no, but I overheard Sky yelling at Drew about it.
Well, you weren't there when Mr. Cantrell left bullets in the gun, right?
Oh, no, I wasn't there.
In fact, when you walked in and overheard this conversation, there was no one else in the shop, right?
The shop was pretty empty.
And once again, after Mr. Coleman spoke with Drew Cantrell, you never saw him repeat that incident.
No.
Now, Mr. Hernandez, you heard about Justice Carbo's injury on May 28th, right?
I did. It's terrible.
You think Drew Cantrell may be to blame.
I wouldn't be surprised.
Mr. Hernandez, I want to be clear. You don't know much about guns, right?
I didn't really use one, so I guess not. But I've been going to the Shooting Star since 2012, so I know some of the basic rules.
Well, you don't own any guns.
No,
You've never even shot a gun.
I've never shot one.
And you weren't there when Justice Carbo got shot, right?
No, I wasn't. I was in my own shop.
Mr. Hernandez, you didn't see what happened.
didn't see it with my own eyes, no.
You have no firsthand knowledge of what took place on May 28th.
Heard about the incident, but I didn't see it.
That's right, you heard about it from some friends.
That's right. I had my chronicles eyes.
And like you said, you read about it in the newspaper. Do I have that right?
Yes, you did.
Thank you, Mr. Hernandez. Your Honor, I have no further questions.
Thank you. Lady Redirect.
Yes, Your Honor. Linda, do you know who you're testifying against today?
Yeah, I do. It's my friend Sky's business, the shooting star.
And how do you feel about testifying against Ms. Coleman?
I do feel a bit bad because the guy's a really good friend of mine. I don't know where I'd be today without him. But the truth is important.
Thank you. Nothing further, Your Honor.
Recross.
No recross, Your Honor.
Thank you so much. You may step down at this time. Thank you for your testimony, Ms. Hernandez. All right, pursuant to Imperion regulations, it's my understanding that the plaintiff rests the case at this time, correct?
Yes, Your Honor, the plaintiff rests.
All right, and unless there are any objections, we're gonna take about a 5-minute break before we allow the defendants to present their case in chief.
Yes, Your Honor.
Yes, Your Honor.
We'll be in recess at this time. Timekeepers, if you will help me to keep track of that 5-minute time period.
Yes, Your Honor.
Thank you.
That's it for me.
He did come in September. I'm sure it's really appreciated with the kiddos. Was on your flight? It's amazing. I can't believe you did this. Yeah. On my point. Oh, you're good. Okay, let me see where our jurors are. All right.
Is Shooting Star Gun Club ready to present your case in chief?
Yes, we are, Your Honor.
You may begin at this time.
The defense called Drew Cantrell to the stand. See?
You may.
Good morning, Mr. Cantrell. Please introduce yourself to the members of the jury.
Hi, I'm Drew Cantrell.
What do you do for a living?
I'm a gun safety instructor at Shooting Star Gun Club.
What qualifies you to be a gun safety instructor?
And I've been handling firearms since I was little. My dad would take me hunting all the time. I learned the most from him. But I also have a firearms safety instructor and a firearms instructor certificate, both from the DOJ.
Are you familiar with the rules of gun safety?
Absolutely. I teach them almost every day in my classes.
Have you ever broken those rules?
I've had 2 write-ups in the 3 years that I've worked at Shooting Star. One of the write-ups was a bit of a misunderstanding, and the other one was for an honest mistake.
After those 2 write-ups, did you ever repeat either of those mistakes?
No, I didn't.
Let's talk about May 28th. Do you remember that day?
I do. I was teaching a safety class to Miss Justice Carvo and Mr. Nick Allred.
Were you familiar with the gun that you'd be using?
Yes, it was a Glock 22, a handgun.
So how did you start the course?
Well, I started by first handing out some safety equipment, eye and ear protection. I then laid down the ground rules for gun safety. That's the most important thing. And then I proceeded how to demonstrate how to actually fire the gun.
Now, before we get to you firing the gun, I'd like to talk about where everyone was standing. Your Honor, we're displaying Exhibit 2G for the members of the jury. It's already in evidence and has been published.
You may do so.
Are you familiar with Exhibit 2G?
One moment, sorry.
Of course.
Yes, I am.
And could you describe what those X's mean for the members of the jury?
Of course. So the blue X is where I was standing. I positioned Justice Carbo on the red X, and then Nick Allred on the yellow X.
So before you fired the gun, were they standing in those positions?
Yes, they were.
Either of them do anything to indicate that they would move from those positions?
No, not at all.
Did you fire the gun?
I did.
Your Honor, permission for Mr. Cantrell to step down and demonstrate to the jury what happened on May 28th.
Permission granted.
Mr. Cantrell, what happened when you fired that gun?
Well, I aimed the gun downrange towards the target, and then I fired the gun. But the recoil on that gun it was stronger than anything I'd ever felt before. It kicked my arm a little bit to the right, and that's when I should have been able to regain control of the gun. But on May 28th, that's not what happened.
What did happen?
Well, my arm moved to the right, and Justice Carbo was standing directly next to me. I had explicitly told her to stand to the right and behind, out of harm's way, but for some reason, she had moved closer to me. When my arm moved to the right, she bumped into me, and the gun pointed downwards. I lost control, and the second shot fired into Miss Carbo's leg.
Thank you, you can sit down. Let the record reflect that this witness made a motion of guns with his hands, then moved to the right, had a bumping motion, then dropped his hands to the ground.
The record will so reflect.
Now, what happened to Justice Carbo after that second shot fired?
She was shot in the leg. She immediately collapsed and started screaming. I called for help, and I'm pretty sure someone called 911.
Your Honor, I'm approaching opposing counsel with what's been marked as Exhibit 2H. Approaching the witness with the same. Do you know what this is?
I do, yes,
Does it look fair and accurate?
it does.
Your Honor, the defense moves to enter Exhibit 2H into evidence.
Without objection, Your Honor.
It's admitted without objection.
And the members of the jury, or may we publish, Your Honor, to the members of the jury?
You may.
It'll be shown on the screen. Now, could you describe what's depicted on Exhibit 2H for the members of the jury?
Of course. This is a picture of stall 11 where I taught the safety class from. It was taken a little bit after the incident. You can tell because of the blood and the police tape.
Your Honor, may we display an overlay of Exhibit 2G and 2H? Both exhibits are already in evidence. This has been shown to opposing counsel.
Any objection?
Yes, Your Honor, as to lack of foundation under Rule 602.
Respond.
Your Honor, I'd ask what opposing counsel is specifically objecting to regarding lack of foundation.
Yes, Your Honor. If opposing counsel wants to overlay these two exhibits, we have to make sure that they're in the same angle, same position where the photographer was, and we need that foundation on the record. Just because it may be apparent doesn't mean that it's proper. And until they lay that foundation, this can't be overlaid.
Respond.
Your Honor, well, it is more likely than not that both of these exhibits are taken from the same angle as well as the same distance, just by looking at them, Your Honor. And then being overlaid, it becomes even more clear to that fact. But I can lay the foundation as to them being taken from similar angles and similar distance off of this witness's rationally based perception.
May I respond on those grounds, Your Honor?
Very briefly.
Yes, Your Honor, it just can't be similar, and it can't be more likely than not. It has to be exact. And if we want to overlay these two exhibits to contradict what happened in today's trial, we need those exact measurements. It's still improper if they don't provide that foundation.
Counsel, I'm going to sustain the objection at this time. If you're able to lay a proper foundation, I'll allow you to do so.
Yes, Your Honor. Well, were you at the scene on Exhibit 2H that's shown? Were you there?
I was.
Did you see that blood spatter?
I did.
And do you agree that those X's are where those three people were standing?
Yes, it is.
And do both of these exhibits appear to be taken from the same angle?
Yeah, they're pretty much the same picture except for the blood and the X's.
Do they appear to be taken from the same distance?
They do.
Your Honor, may we now share that overlay of the two exhibits?
Is there still an objection?
Yes, Your Honor. 602, lack of foundation once more. As I raised prior, we need exact conclusions on whether these two were taken from the same angle. Just because this witness is kind of able to confirm this information, that doesn't make it proper for the members of the jury. They can't overlay these exhibits until we get that exact foundation.
Maybe heard, Your Honor.
You may.
Your Honor, the burden for evidence coming in is a preponderance of the evidence, more likely than not. Any small differences that opposing counsel thinks are there are not present on these two exhibits. Your Honor, they're already in evidence, and this witness can testify because he was there where that blood spatter was in relation to that blue X.
You may close on your objection.
Yes, Your Honor, while the standard for entering evidence like this is more likely than not, that's not what happened. That is not what's happening in this scenario. They're trying to create a demonstrative aid for the members of the jury to show where that blood splatter is in relation to Exhibit 2G. It's not the same burden in today's case, and they have to get those exact measurements from an expert. Drew Cantrell isn't qualified to make those conclusions. Therefore, this still lacks foundation for it to be overlaid.
I'm going to overrule the objection. I'll allow you to do the overlay as a demonstrative. And with regard to the weight of the evidence, I'll allow you to cross-examine that.
Yes, Your Honor.
Yes,
You may continue.
That overlay will now be shown on the screen. Now, a moment ago, Mr. Cantrell, you said that Justice Carville moved closer to you. Looking at this overlay, when you fired that first shot, pulled the trigger, was Justice Carville standing on that red X in Exhibit 2G where you told her to stand?
No, she wasn't.
Where was Justice Carville standing?
I said she was almost right on top of me. She was standing right where that blood is in that picture.
Thank you. Your Honor, I have no further questions.
City Croft,
Yes, Your Honor, we'd ask if that overlay was left on the screen.
you can please put that overlay back up. Thank you so much.
Mr. Cantrell, I want to start by talking about this overlay you were shown on direct examination.
Of course.
You weren't the person who took the photo in Exhibit 2G, were you?
Yeah.
You weren't the person who took the photo in Exhibit 2H, right?
Sure.
So I want to talk more about what you also testified to on direct examination. I remember, you still work at the Shooting Star Gun Club, right?
That's right.
That's right, and at this point, you've been working there for 3.5 years, right?
About 3.5, that's correct.
And you didn't just start as a firearm instructor, did you?
Of course not. No, I started as just a sales clerk.
That's right, and it's safe to say that in all of this time, you've learned a bit about gun safety, right?
Yes, I have.
You know how important it is to follow gun safety, right?
I do.
So let's talk about what happened when the Shooting Star Gun Club put a gun into your hands.
Right.
Could you flip to Exhibit 20 in that exhibit booklet, sir? Okay. Sir, these are written reprimands you received for breaking gun safety rules, right?
That's right. Skylar Coleman gave me this reprimand.
That's right. These are written by Skylar Coleman, correct?
Yes, they are.
It's a fair and accurate copy of that written reprimand you received.
Yes, it is.
The plaintiff offers Exhibit 20 into evidence.
Any objection to Exhibit 20?
Yes, Your Honor, as to hearsay, may I be heard?
You may.
Your Honor, I'm objecting specifically to a portion of this exhibit. It's the portion of the two incidents where it says, I received a report that, in violation of company policy and best practices, you aimed a firearm at another person in the gun shop. And then the following one. Your Honor, well, I do know that this was written by Skylar Coleman. Those statements, I received a report, and what follows, not I received a report, but what follows, that is hearsay. Because it is what Skylar Coleman heard from someone else, and it's inadmissible in court today because it's made up.
Any response?
Yes, Your Honor. In order for a hearsay statement to be inadmissible, it must be a verbal assertion taken out of court for the truth of the matter asserted. And that's not what we're trying to do with these reports. We're not offering these reports to conclude that this is exactly what happened on those 2 days, merely to show that those reports will influence Skylar Coleman to make this written reprimand. They're not offered for the truth of the matter asserted, merely the effect on the listener.
Close on your objection.
Yes, Your Honor. If this is offered specifically for that purpose, for an effect on the listener of Skylar Coleman, we have no objection. We just ask that a limiting instruction be provided to the members of the jury.
I am going to allow the admission of Exhibit 20 with the stipulation that it is not being offered for the truth of the matter asserted. And the jury is only to consider this exhibit for its effect on the listener and not for the truth of any matter asserted in the second part of that, by Skylar.
Yes, Your Honor.
You may continue.
Yes, Your Honor. Now, Mr. Cantrell, can you see this demonstrative aid I'm holding right now?
Yes, I can.
And sir, this is an accurate representation of what's in front of you, right? I can tilt it a little bit more if you'd like.
Please. Yes, it does look like what I have right here.
So, sir, I want to verify some statements that are on this report with you.
Okay.
May 2021, I received a report that in violation of company policy and best practices, you aimed a firearm at another person in the gun shop following a verbal argument. Did I read that correctly?
You did.
And sir, you'd agree with me in saying that if you were to have pointed a gun at another person, that would be a pretty serious violation, right?
It would be, and I didn't point a gun at anybody.
That's right, but you weren't fired after Mr. Coleman found out about this, right?
I didn't point a gun at anybody. Skylar Coleman didn't find out about that.
Bringing you back to my question, other than this memorandum, you weren't fired, were you?
Of course not. No.
You weren't suspended?
No.
You weren't demoted?
No.
You weren't retrained? You just got a stern talking to and a written reprimand, correct?
That's right. Skylar Coleman gave me a pretty long lecture about the rules for gun safety, and then also did that memorandum there.
But nothing else, right, sir?
That's right.
You were actually promoted 3 months after this incident, right?
That's right. After I received a firearms instructor certificate, I was promoted.
So I actually want to talk more about that promotion for the members of the jury.
Of course.
Mr. Coleman didn't interview you for that position.
For the instructor position?
Yes, sir.
No, I was already working at Shooting Star.
Mr. Coleman never sat down at one of your gun safety lessons, making sure you could demonstrate gun safety, right?
Not to my knowledge.
So you never saw Mr. Coleman watch any of your gun safety lessons, right?
I didn't see it. No.
That's right. And Mr. Cantrell, you mentioned that you got a firearm instruction certificate. You never showed that to Mr. Coleman, did you?
Well, he made sure that I received one. I had to fill out some forms in front of her, and I did receive that instructor certificate.
Is it your testimony today that Skylar Coleman received the paperwork for that firearm instruction certificate?
Not sure if he received that paperwork, but he did have me fill out the forms necessary to receive the certificate.
But that's right, you never provided him with that certificate, did you?
I just filled out the forms that were necessary. That's right.
So that's a yes to my question.
It is.
Mr. Cantrell, Mr. Coleman also never asked you for that certificate, right?
No, just for me to fill out the forms.
So I want to get back to this exhibit for you. Once again, confirm if I'm reading this correct. November 2021, I received a report that in violation of company policy and best practices, you returned a firearm after completing a safety course, but failed to empty the chamber of all ammunition. Did I read that correctly?
You did.
And sir, you did bring a loaded gun outside of the gun range, right?
That's right. It was an honest mistake. Skylar Coleman gave me a ruthless lecture afterwards, and I made sure to never repeat it again.
That's right. It's your testimony today. You never once brought a loaded gun outside of the gun range, right?
No, I did in November 2021.
After
that, I didn't.
So
That's
it's your
right.
testimony today, just clarifying this, is that after November of 2021, you never brought a loaded gun outside of the gun range.
That's right.
After this incident, you weren't fired, were you?
No.
You weren't suspended?
No.
You
I
weren't.
continued working as an instructor.
That's right, and you weren't retrained to continue working as an instructor, did you?
No.
You got this written reprimand
That's right.
and another stern talking to.
It was a ruthless lecture. I sat down with him for what seemed like an eternity, and he went over almost all of the gun safety rules.
Is it your testimony today that in that ruthless lecture, he went over all the gun safety rules?
Even over the ones that I violated, and the one about, keeping keeping a loaded gun on the range, not in the shop.
So he didn't go through all of the gun safety rules, did he?
I only violated once, so he just went over that one.
So that's yes to my question. He didn't go over all of the gun safety rules.
Of course.
So I want to talk more about what happened on May 28th, 2022. Sir, it's your contention today that after you shot that first bullet, you lost control of the gun, right?
After Miss Carter bumped into me, I lost control of the gun.
That's right, and after that happened, the gun started to fall, right?
It did. After I lost control of it, it fell to the ground.
You didn't just let it fall, did you, Mr. Cantrell?
What do you mean?
Sir, when that gun started to fall, you tried to grab it, right?
I tried to maintain my grip, but I couldn't, and that's why it fell to the ground.
But you did try to grab that gun to maintain that grip, right?
I tried to, but I failed.
Sir, you're not aware of any safety violations you made when you tried to re-grip that gun, are you?
I tried to maintain my grip. I didn't re-grip the gun. The difference there is that if you re-grip a gun, that means you've already lost control of it, and you attempt to re-grab it. I just tried to maintain my grip, but I couldn't, and that's why it fell out of my hands.
That's right, and you're not aware if you violated any best practices of gun safety when you tried to maintain your grip on that falling gun.
I tried to keep control of it. No.
The Shooting Star Gun Club actually never taught you anything about how to grip a firearm, right?
No, I had to learn how to grip a firearm when I had my safety certificate.
It's your testimony today. You learned how to grip a firearm when you got that safety certificate.
Of course, the standard procedure on how to grip a firearm.
But sir, you didn't write that in your report, did you?
No, I think it's pretty clear that you learn how to re-grip, or excuse me, how to grip a gun when you're learning how to handle the gun.
You actually don't mention anything about what you learned in that safety certificate training, did you?
That's right, just that I got it from the Department of Justice.
Or do you mention any training you went through for that certificate?
I did have to take some courses to receive that certificate, but I don't mention the specifics of those courses.
Nothing further at this time.
Redirect?
Yes, Your Honor, I ask that opposing counsel take down their demonstrative.
Yes, Your Honor, that's fine with us.
Please do so at this time.
Counsel just talked about your certification in today's case, how you became a firearm safety instructor. Now, where did you receive that certification from?
I received both certificates from the Imperial DOJ.
Do you consider Skylar Coleman to be above the Department of Justice?
Of course not, the Department of Justice, the government.
Thank you. Your Honor, I have no further questions.
Recross?
No recross based off this information, Your Honor.
Thank you so much. This witness may step down. Thank you for your testimony. All right, defendant may call its next witness.
Yes, Your Honor, the defense calls Avery with. Good morning. Please introduce yourself to the members of the jury.
Hi there, I'm Avery Wynn.
What do you do for a living, Mr. Wynn?
I'm an engineer. Well, no, I don't do that for a living. I work at a bank.
Do you do any engineering?
Oh, absolutely. I've created a ballistics engineering workshop in our basement with my mom.
All right, Mr. Wynn, I want to turn your attention to today's case.
Are you familiar with Shooting Star Gun Club?
Yes, that's where I go to test my ballistic customizations.
Could you tell us how much time you spent there?
A lot. See, I don't make a lot of friends at the bank, so my mom told me to go to Shooting Star. And some people actually came up and talked to me.
Well, Mr. Wynn, I want to talk about those experiences at Shooting Star. Have you ever purchased a firearm from them?
I have, yes, several times in fact.
What was that experience like?
It's great. You know, as an engineer slash bank teller, I'm a connoisseur of organization. Shooting Star runs me through the same routine every single time.
Mr. Wynn, what does that routine entail?
They always give me paperwork. I love paperwork. And then they always give me the option if I need a safety course, which of course I haven't needed for years now. I am well familiar with the safety rules of gun operation.
Do you know who teaches those safety courses?
That would be the safety instructor, Drew Cantrell.
All right, Mr. Wynn, I want to talk about May of last year. Do you remember what you were doing that day?
Yes, I was at Shooting Star, fine-tuning some of my special customizations at my shooting stall as usual.
Did you see Mr. Cantrell while you were there?
I did. He walked in and started teaching his safety course at stall 11.
Do you know who he was teaching?
I was introduced to some more friends, Justice Carbo and Nick Allred. You know, I told them if they worked hard at the gun range, they could end up like me.
Mr. Wynn, did you see Mr. Cantrell handling that firearm?
I did. After he finished going through the basic rules, he prepared the gun, aimed it, and fired it downrange.
Mr. Wynn, where were the people he was teaching? Justice Carbo, all right, Sandy.
They were both to the right of Drew. First, Miss Carbo, and then Mr. Allred.
Now, did you see anything out of the ordinary happen right before Mr. Cantrell fired that first shot?
Yes, actually, I did.
What did you see Mr. Cantrell do?
Oh, it wasn't Cantrell. It was Carbo. Right before Drew fired the first shot, Miss Carbo just suddenly crowded in really close to him.
Did you see Mr. Cantrell make any sudden movements?
Oh, no. He fired the gun just like how I would have done.
And Mr. Wynn, what happened when that first shot was fired?
You know, I seem like a pretty tough guy. It was hard to watch. I saw Miss Carbo fall to the ground. And as I said earlier, she was standing so close to Drew. She bumped into Drew's arm. And that's when the second shot was fired. I saw Miss Carbo fall.
Thank you, Mr. Wynn. Your Honor, I have no further questions.
Lee Cross?
Yes, Your Honor. May I proceed?
You may.
Good afternoon. Hi there. You've been going to the Shooting Star since at least 2005.
That is correct.
And in the 18 years you've been going to the Shooting Star, you've only ever seen one employee break the gun safety rules you know.
It's true. Only one time. They're very good at what they do.
That's Drew Cantrell, right?
The safety instructor.
Drew Cantrell took a gun and pointed it at someone else.
It's true. It was for a moment.
You saw the owner of the Shooting Star, Mr. Coleman, school Drew Cantrell for this.
I did. It was much deserved. He was right in to do so.
I want to change gears and talk about May 28, 2022.
Okay.
You were in the Shooting Star on May 28.
I was.
And you say you saw that training course that took place on May 28th.
I did.
They were at stall 11.
It's true. That's where the safety was taking place.
You were at stall 3, right?
Yes, sir. Avery's counter. I'm well honored to be named it after me.
Mr. Nguyen, I want you to point to somewhere in this courtroom you believe is about 30 feet away.
Maybe do that stand over there?
That easel, sir?
Yes.
Let the record reflect that my co-counsel, Lindsay Gogia, is now taking a measuring tape to the witness stand, and I'm taking the end to the point that Avery Nguyen indicated. Could you read the closest black number on that measuring tape, sir?
40.
Good guess, Mr. Nguyen. You were about 10 feet closer than this distance, right?
That is right.
You say you saw Justice Carbo bump into Drew Cantrell from about 10 feet shorter than this.
That is true. I had a very clear view, but not the best.
You say you had a clear view, but you were making some ballistic customizations, right?
That is true. I was multitasking. It's one of my better suits.
So you were making a ballistic customization at your table, right?
That is true.
So you saw everything from the corner of your eye.
To be more precise, I saw through my peripheral vision.
So that's a yes.
Through my peripheral vision. That is correct.
Nothing further at this time.
Thank you.
Redirect, Your Honor?
Redirect.
Ask if I can use the tape measure that opposing counsel is using.
Feel free.
Thank you. And I asked if my co-counsel can assist me.
She may.
Mr. Nguyen, can you read the number on that tape measure there?
Objection, Your Honor, as to leading. May I be heard? On direct examination, opposing counsel isn't supposed to ask a question that their own witness that suggests the answer, and they're asking Mr. Nguyen and leading him to read what's on that measuring tape.
Your Honor, may I be heard?
You may.
Your Honor, I asked this witness if he can read the number on this tape measure. That's not a leading question. I'm not suggesting an answer.
So who?
Yes, Your Honor.
Mr. Nguyen, can you read that number?
It reads 30 feet.
So is this how far away Mr. Cantrell was standing?
Precisely.
And are you able to see me clearly?
Very clearly.
Thank you. Your Honor,
Recall.
Yes, Your Honor. As you just said, this is about 30 feet away.
30 feet away. You are correct.
Again, you weren't looking at him head on, right?
No, through my peripheral vision, and I can see you very clearly, as I said.
That's right, you were looking through your peripheral vision because you were focused on your ballistic customization, right?
That is true. Through my peripheral vision.
Thank you, Mr. Nguyen. Nothing further at this time, Your Honor.
Recall.
No,
I'm sorry, redirect.
nothing further, Your Honor.
All right, you may step in. Thank you for your
Thank you, Your
testimony. All right, defense may call its next witness.
Yes, Your Honor, the defense calls Jack Staub to the witness stand. May I proceed? You may. Good morning. Please introduce yourself to the members of the jury.
Good morning, everyone. My name is Jack Stoll.
What do you do for a living, Mr. Staub?
Well, I'm a firearms examiner at a company I founded in 2012, Stoll Examiners.
Is that an accent I hear?
Yes, ma'am, it is. I'm from Western Australia. I moved over here when I was about 16. My mum's from America. My father's from Australia.
Did you have any prior experience with firearms?
Absolutely, ma'am. I graduated from West Point with a degree in physics, and I was deployed with the United States Army to Iraq in 2003. I was honorably discharged in 2010 as an officer distinguished in expert pistol marksmanship. I also hold safety certifications from the Imperial Department of Justice and the United States Bureau of Alcohol, Tobacco, Firearms, and Explosives.
And are you published?
Absolutely, ma'am. On the topic of gun safety and firearm mechanics, I've been published several times in the last 2 years.
How are you involved in today's case?
I was retained by defense counsel to analyze the circumstances surrounding Justice Carbo's injury. Specifically, I analyzed the events leading up to the injury, but primarily I focused on the cause of the injury.
How are you qualified to analyze the causes of a firearm-related injury?
Well, ma'am, I specialize in safety and mechanical analysis, both of which are crucial in determining the cause of a firearm-related injury. On the safety side, we look at how the operator may have contributed to an injury. And on the mechanical side, we analyze the gun itself to determine how it may have contributed to an injury. My expertise covers both aspects.
Your Honor, we tender this witness as an expert in firearms safety and firearms mechanics under Rule 702.
Any objection?
None, Your Honor.
This witness will be qualified as an expert in the fields of firearm safety and firearm mechanics. You may continue your examination.
In coming to your conclusions, did you rely on sufficient facts and data?
Yes, ma'am. I reviewed numerous affidavits and eyewitness accounts of the events and a personal examination of the actual firearm that was discharged in today's case.
Your Honor, I'm approaching this witness with what's been pre-admitted into evidence as Exhibit 1. Could you tell us what this is?
Sure, ma'am. That's the Glock 22, the pistol I was hired to analyze.
Did you perform your analysis using methods that are standard in your field?
Of course, ma'am, using safety and mechanical analysis.
I want to get into your conclusions here. You said you analyzed what led up to Justice Carbo's injury. What do you mean by that?
I was asked to determine whether Drew Cantrell, the operator of the firearm that injured Justice Carbo, whether he was safe to operate that firearm. And I concluded that he was.
Why did you conclude that?
Mr. Cantrell was and still is certified as a safety instructor with more than a decade of firearm experience. But man, few people could be more qualified to handle firearms.
What about instances of safety violation? Wouldn't that disqualify Mr. Cantrell?
Not at all. There were 2 minor safety violations which never were repeated and happened in the span of 10 years of gun handling. None of these instances involved firing a weapon, and quite frankly, it's very impressive that Mr. Cantrell had a safety record as clean as that, especially considering the amount of time he spent handling firearms.
Moving to your second area of analysis, you said you analyzed what caused Justice Carbo's injury. What did you conclude?
I found that the gun used by Drew Cantrell had a faulty mechanism. In other words, an overly sensitive trigger. This overly sensitive trigger, not a safety violation, which caused Justice Carbo's injury.
How were you able to conclude that the gun's trigger was faulty?
Well, I examined a Glock 22, usually well suited for beginners. And I found that the trigger's sensitivity was incorrectly calibrated. It was overly sensitive.
What does incorrectly calibrated mean?
Well, the gun's trigger needs to be light enough that it can be pulled smoothly, but it needs to be heavy enough
that can be called accidental. And I found that this particular trigger was dangerously light.
Well, moving to the second part of that conclusion, Mr. Staub, how are you able to conclude that the faulty trigger is what caused Justice Carbo to be shot?
There are two ways in which the faulty trigger was responsible. Now, after each successive discharge of the firearm, the situation became more and more dangerous due to no fault of Mr. Cantrell.
Well, let's start with the first discharge of the firearm. What effect did the faulty trigger have at that moment?
When Mr. Cantrell first fired the gun, he noted that something was off with the mechanism and the recoil, that's the backwards force that a gun has, was much harder to control than normal.
How does the recoil relate to the pulling of the trigger?
Maybe you can record it's like to drive a car you've never driven before. If the gas pedal takes less force to accelerate than it used to, with only a light touch to the gas pedal, the car can jump out of control. And the same is true of pulling the trigger on a gun. If the gun discharges significantly earlier than you expect, it's very hard to maintain control.
Did Drew Cantrell react properly to the recoil from that first shot?
Absolutely. He handled the dangerous situation in the safest way possible. Now, Mr. Cantrell absorbed the force of the recoil by allowing his arms to shift to the right. And at that point, he had safe and secure grip on the firearm, and it had not fired a second time.
Well, if Mr. Cantrell didn't cause the gun to fire a second time, did you come to a conclusion as to what did?
Man, there were multiple eyewitness accounts, and specifically, the overly sensitive trigger has a very specific flaw. An overly sensitive trigger is one that only requires a light stimulus to refire.
Did you identify anything in this case that could have been such a stimulus?
Yes, ma'am. The eyewitness testimony revealed that when Drew Cantrell's arm shifted to the right to absorb the force of the recoil, Justice Carbo's arm actually collided with Mr. Cantrell.
Well, I want to make something clear. When Justice Carbo's arm hit Drew Cantrell's arm, was there anything Mr. Cantrell could have done to prevent that second shot from firing?
Unfortunately not. You see, Mr. Cantrell has safe and secure grip on the pistol before the collision. Now, if the gun's trigger had not had an overly sensitive trigger, that could have been enough to prevent the second shot.
Thank you. Your Honor, I have no further questions.
Any cross?
Yes,
Good afternoon.
How you going, counsel?
Direct examination, you said that you conducted an examination on the Glock 22, right?
That's right, I did.
In your report, you didn't include the methods you used during that examination.
Not these specific methods, I included the results of the examination.
But not the methods you used.
That's right, ma'am.
Let's talk about some of the conclusions you formed in your report.
Of course.
Drew Cantrell is currently employed as a firearm instructor, isn't he?
Yes, ma'am. Shooting stars involved.
He claims to have a certification in firearm safety instruction, right?
Ma'am, he does hold a safety certification by the Imperial Department of Justice.
He claims to have a certification in firearm safety instruction, right?
That's right, ma'am, yes.
You never saw that certification, did you?
Not a specific certification, no.
You never found any evidence outside of Cantrell's own affidavit that he has that certification?
Well, ma'am, I believe Mr. Skylar Coleman promoted him to safety instructor because he had that certification.
You don't know that Mr. Coleman saw that certification, do you?
And I believe he did. That was part of the reviewing process in the promotion.
You're familiar with Mr. Coleman's affidavit, aren't you?
Absolutely, ma'am, yes.
Let the record reflect I'm putting opposing counsel with the affidavit of Mr. Coleman.
The record will so reflect.
And the witness with the same. appears to be Mr. Coleman's affidavit, right?
Looks to be it.
Sir, can you take this Sharpie and circle where in that deposition it says that Mr. Coleman saw Drew Cantrell's firearm safety instruction certificate?
Well, ma'am, I don't believe he saw it. I believe it was part of the interview process.
So Mr. Coleman didn't see Mr. Cantrell's firearm safety instruction certification.
That's right. We don't have specific testimony that he saw it.
Talk about another one of your conclusions. You would agree that it's best to maintain a firm and still grip when firing a gun.
Absolutely, ma'am. That creates a firm platform to fire the gun from.
It allows for easier management of recoil.
Of course.
Having an overly relaxed grip can lead to an unmanageable fire.
That's right, ma'am. It's critical to maintain a firm and stable grip.
It can even lead to an accidental firing.
I believe so. That's right.
Now let's talk about your conclusions of the May 28th, 2022 incident.
Of course.
You concluded that Drew Cantrell did not flinch for firing the weapon on May 28th.
That's right.
Your conclusion best aligns with the eyewitness testimony of Avery Nguyen.
Avery Nguyen and Mr. Cantrell.
Avery Nguyen was standing on the opposite side of the shooting range, right?
He was at that stall 3.
And he was only looking from the corner of his eye.
That's right. His peripheral vision.
Right. There were 2 other eyewitnesses there that day.
There were.
Both of those people were standing closer to Drew Cantrell than Avery Nguyen.
That's right, and there were.
Thank you. No further questions.
Redirect.
Yes, Your Honor.
Mr. Scott, opposing counsel asked you a lot about having a firm grip on a gun. Did the second shot fire in this case because Drew Cantrell didn't have a firm grip on that gun?
Absolutely not, ma'am. I'd like to be very clear. The cause of the second shot wasn't because he maintained his grip, but because of an overly sensitive trigger that had taken a light stimulus for the gun to refire.
They also asked you a lot about the testimony that you relied on. Can you tell us why you relied on Avery Nguyen's testimony instead of Nick Allred's?
Of course. Now, Mr. Avery Nguyen was exceptionally experienced with firearms and had a fair view of what was happening that day. However, the eyewitnesses who were right next to Mr. Cantrell, very little experience. Like one eyewitness, Mr. Nick Allred, is actually unsure of his testimony. I didn't find it reliable.
Thank you. Your Honor, I have nothing further.
Any recall?
No, Your Honor.
Thank you so much. This witness may step down. Thank you for your testimony.
Thank you, Your Honor.
The defense rests, Your Honor.
Thank you so much. Pursuant to Imperion rules, it does appear that the defendant has rested. The evidence in this case is closed. And unless there is an objection from either party, we are going to take about a 5-minute break, and then we will proceed with your closing arguments or summation.
No objection from the plaintiff, Your Honor.
That's all right with the defense.
And then we will be in recess for 5 minutes. Let me have my timekeepers assist me in keeping up with that.
Yes, Your Honor.
Thank you. let me inquire from both parties. Are we ready to proceed with closing argument?
The plaintiff's ready to go, Your Honor.
The defense is rel.
All right, and I believe I've got all of my drawers. So in this jurisdiction, the plaintiff does have the ability to both open and close summation. Let me inquire from plaintiff at this time, how much time, if any, would you like to reserve for rebuttal?
Your Honor, any time I leave on the table after my opening and closing argument.
All right. And do you wish to both open and close?
Yes, Your Honor.
You may begin.
Permission to set up demonstrative before I continue?
You may.
If I may reposition myself to see the demonstrative.
Absolutely.
Karthik Ratna Sabhavati, on behalf of Justice Parvo, please the court. They put a gun in the wrong hand. I want to start by reminding you why we're here in court today. It's because of a woman who just wanted to be safe. A woman who went to the Shooting Star Gun Club because she was scared to go to her. A woman who went to this company looking for protection. But members of the jury, when she walked into the Shooting Star Gun Club, she didn't get that safety. She didn't get that security, and she most certainly didn't get that protection. Because members of the jury, Justice Carbo didn't walk out of that gun range with a gun in her hands. She was carried out on a stretcher with a bullet hole in her leg. All because they put a gun in the wrong hands. Because members of the jury, this company put a gun in the hands of an instructor who had broken rule after rule at the Shooting Star Gun. They put that gun in the hands of an instructor they held above the standard. But members of the jury, you can't do that. Because in this courtroom, people who break the rules are held accountable. People in this courtroom are not held above the standard. And members of the jury, it's for those reasons Justice Carbo has charged the Shooting Star Gun Club with negligent hire. Members of the jury, we have to prove that charge by preponderance of the evidence. Now, what does that mean? It means that we had to prove, more likely than not, that this defendant hired an incompetent employee. And it's because of that employee, my client has a bullet hole in her leg. And members of the jury, we proved that to you today. We proved that to you today by focusing on the 3 points Mr. DeVoe mentioned at the beginning of today's trial. Because Drew Cantrell should have never had a gun. The Shooting Star Gun Club knew that. And they put a gun in his hands. And now I want to break this down for you, members of the jury, starting with that first. Drew Cantrell should have never had a gun. This one's easy. Members of the jury, they called witness after witness who have corroborated the fact that this employee is incompetent. Pointing a gun at another person, taking a loaded gun outside of the gun range, members of the jury, he's a walking example of what not to do in a gun range. You see, he didn't know what he was doing inside of the gun range. He didn't know what he was doing outside of it. And he most certainly wasn't qualified to train Justice Carbo. And second, the Shooting Star Gun Club knew that. Because members of the jury, today you learned that they knew everything that I just told you. Today you heard their solutions for those problems. I'm going to show you what they should have actually done. Because members of the jury, breaking gun safety rules isn't anything to be laughed at. You see, when you point a gun at another person, you need to be suspended. You need to be retrained. Something has to happen to make sure this won't happen again. But all this instructor received was a reprimand. You see, members of the jury, when you break another gun safety rule in the same year, you need to be fired. You need to be demoted. You need to send a message to guarantee that that won't happen again. But all this company did was reprimand this employee again. And today they suffered the punishments to not punishing this employee. And they're scrambling today, members of the jury. Oh, it was a faulty gun, that's why it went off. Justice Carbo bumped into his arm. They're scrambling, trying to find a solution to cover the problems of their employee. And third, the Shooting Star Gun Club put a gun in his hand. Anyway. See, members of the jury, I wrote down something during today's trial that I want to talk about. On the direct examination of that instructor himself, the question was, what do you do for a living? And the answer was, I work at the Shooting Star Gun Club as a firearm safety instructor. Members of the jury, he still works there. He's still managing the gun range, making sure nobody breaks the gun safety rule. He's still teaching gun safety courses, and he's still able to work at that company despite everything that he's done. Because despite everything that you've heard today, they are going to continue to put a gun in his hands. I'm going to talk about the credibility of their expert witness today, members of the jury. Because today you learned about the events that happened on May 28th. Whether Drew Cantrell bumped into Justice Carbo, or whether Justice Carbo did the opposite. Now, this witness took the stand, and he testified, I took the word of Avery Newell, a witness that was standing 30 feet away. And members of the jury, it's not like he was just looking at Avery. It's not like he was just looking at Drew Cantrell. Members of the jury, Avery Newell was standing 30 feet away, looking from the corner of his eye. Now, I don't know about you, members of the jury, but when I'm looking through the corner of my eyes, I can barely see past 10 feet. And he told you today that he took that opinion rather than the testimony of a witness who was mere feet away. Members of the jury, that is faulty logic. Members of the jury, we can't control whether the Shooting Star Gun Club's going to continue to put a gun in the wrong hands. Because it's not as easy as stopping the negligence of one company, just one trial. But members of the jury, what we can do is send a message. we can make sure that the Shooting Star Gun Club has consequences for their actions. Because that's the power you have in this court. And it's for those reasons Justice Carbo asked you to find this company liable because they put a gun in the wrong hands. Thank you.
Thank you for your argument. Shooting Star Gun Club, you may begin your summation at this time.
Yes, Your Honor, opposing counsel to take down their stand.
Yes, Your Honor.
And if we could put up our own overlay,
You
as you saw on the screen before. May it please the court. This is a case about a faulty trigger and faulty logic. It's the late morning. Drew Cantrell is teaching a gun safety course. Now, he's already gone over the rules, so now he's preparing to demonstrate how to fire a gun. This gun, it sits steadily in his hands as he points it downrange. He takes a breath, squeezes the trigger, and bang! He shoots the target, misses a bit to the right, and blasts it off with his students as he gives them their turn and finishes up the course. Everyone goes home happy. Members of the jury, that might not sound like what happened on May 28th, but it is what happened at every single gun safety course that Drew Cantrell taught for almost a year leading up to May 28th. It's what happened when Drew Cantrell used a gun that worked like it was supposed to work. It's what happened when his students stood where they were supposed to stand. Members of the jury, the only reason why this case is different, the only reason why we're here today, is because of a faulty trigger and plaintiff's faulty logic. Now, the plaintiff had the burden today to prove that the Shooting Star Gun Club negligently hired someone and that it directly related to Justice Carbo's injury. Now, I want to be clear about what all that means. It does not mean that opposing counsel can just prove that Drew Cantrell caused Justice Carbo's injury and be done with it. No. They actually have to somehow show that Shooting Star had the knowledge and responsibility to fire Drew Cantrell before May 28th even happened. If they fail to prove either of those things, you must find us not liable. Today, they failed to prove both. Now, the plaintiff's faulty logic, it starts with their determination that Drew Cantrell needed to be fired after 2 incidents in multiple years. Members of the jury, in law, we have rules for attorneys that stop us from judging someone based off of just 1 or 2 incidents, because that makes logical sense. So why should we have expected Shooting Star to have done any different? You can't judge someone based off of 1 or 2 instances, especially when those 2 incidents are in contrast to everything else you know about a person based off of years of information. But even if you agree with the plaintiff, even if you agree that 2 incidents meant that Shooting Star needed to fire Drew Cantrell, you still must find for Shooting Star. Because the plaintiff also had to prove that Drew Cantrell's irresponsibility caused Justice Carbo's injury. They failed on that as well. Members of the jury, we aren't here because of Drew Cantrell. We're here because of an intervening and superseding cause. 2 causes, in fact. We're here because of a faulty trigger and the plaintiff's faulty logic. Today you heard from Jack Staub, an expert in firearms mechanics, the only expert who provided you with a detailed analysis of the actual gun used in the incident. Now, let's talk about the plaintiff's expert for a moment. Now, the plaintiff got up here and told you, their expert, Dr. Jett, that, well, she didn't provide any details about her analysis of the gun because that's not in my expertise. I guess it was in her expertise to examine the gun, just not to tell you about it. But Jack Staub's conclusion, that conclusion is one that the plaintiff simply cannot dispute. That gun's trigger was faulty. It was overly sensitive. It could be pulled with the lightest of touch. Members of the jury, Jack Staub described to you how this faulty trigger caused Drew Cantrell to lose control of that gun and how it made stopping a second shot nearly impossible. That faulty trigger, that is the first intervening and superseding cause of that accident. But Jack Staub told you that Drew Cantrell actually did stop a second shot. That was until Justice Carbo bumped into him. How did that happen? Take a look at this diagram. This is where the plaintiff wants you to believe Justice Carbo was standing when Drew Cantrell bumped into her. This is where we've hit faulty logic, members of the jury. Now, you heard from a lot of different witnesses about what happened here, so let's walk through it. Drew Cantrell absorbed the recoil and swung around, hitting Justice Carbo. Now, according to the plaintiff herself, she was standing here on that red X behind Mr. Cantrell, where she was told to stand. That means in order for this to work, the recoil from this beginner's handgun would have to be so strong that Drew Cantrell swung almost 180 degrees, somehow executing a perfect pirouette before slamming into the plaintiff. Members of the jury, before we even begin to examine the surrounding evidence, it's already clear. That's faulty logic. Justice Carbo had to have moved for that to make any sense. That's exactly what you heard from our witnesses today. Drew Cantrell, he told you that Justice Carbo moved closer to him when he fired that gun for the first time. You also heard from another witness, an unbiased third party named Avery Wynn. Mr. Wynn told you that he, when he was watching from another shooting stall, saw Justice Carbo move closer to Drew Cantrell. Now, members of the jury, the plaintiff tried really hard to make that evidence faulty. They were unsuccessful, but they tried by bringing an actual tape measure, which I think is a bit excessive, to the stand today. And they asked my witness to say where 30 feet was. He actually said farther, showing first that he could clearly see farther than 30 feet. Then, me and my co-counsel, Kate Brody, got up here with that same tape measure, measured out 30 feet. He asked Mr. Wynn, "Can you see from this distance?" "Yes, I can see." "Can you see with this distance through your peripheral vision?" "Yes, I can see." Members of the jury, he could see from that distance, he could see Justice Carbo move. But if that wasn't enough, we've got the physical evidence to back us up. Take a look at this photograph of the bloodstain, Justice Carbo's blood. Compare that to where Justice Carbo told you she was standing. I think we can all see a difference. That blood is right next to Drew Cantrell. Members of the jury, if the blood stained the eyewitness testimony, the mere fact that contact was made at all in today's case tell you that Justice Carbo disobeyed instructions, you should follow that evidence. Evidence of a second, intervening, and superseding cause. Somehow, the plaintiff's logic, that led them elsewhere. Now, the plaintiff also told you today that this case is about Shooting Star putting a gun in the wrong hands. That's not hard to believe. If you don't ask the right questions. It's not hard to believe that Drew Cantrell should have been fired until you take a step back and you see that he only had 2 incidents with 10 years of experience. It's not hard to believe that Justice Carbo actually did stay where she was supposed to stand. Until you compare that testimony with the rest of the evidence. Members of the jury, for a moment, you might think that Drew Cantrell failed the plaintiff. Can you see that before any of that? Drew Cantrell was failed by the gun in his hands, by a faulty trigger. That's what this case is about, members of the jury. A faulty trigger and faulty logic. I ask that you find Shooting Star Gun Club not liable. Thank you.
Before we receive the rebuttal, may I ask the timekeepers how much time is remaining?
Of course, the plaintiff has 2 minutes and 51 seconds remaining for rebuttal.
Thank you.
Your Honor, would opposing counsel like me to take down my demonstrative?
Yes, Your Honor.
Yes. You may begin when you're ready.
Let's talk about a faulty trigger and faulty logic, members of the jury. If that gun really had a faulty trigger, then of course it's reasonable for this employee to make sure it was functioning properly before he went to go train with it. But according to the defense, that's proper. Members of the jury, let's talk about faulty logic. It's reasonable to take the eyewitness account of someone standing 30 feet away, focusing on his ballistic customizations, watching through the corner of his eye, rather than a witness standing 2 feet away. Members of the jury, the only faulty logic that's involved in today's case is the fact that this defendant never punished their faulty instructor. Members of the jury, there was nothing wrong with that trigger. Mr. Carbo didn't bump into anyone's arms. This only happened because they put a gun in the wrong hands. Don't believe defense counsel's claims when they don't have any evidence to back it up. Thank you.
And that concludes Justice Carbo versus Shooting Star Gun Club. Ladies and gentlemen, we have reached the portion of the trial where we take a deep breath and give these scholars a wonderful round of applause. I give the evaluators a few more moments to put in any last words or comments. And while they're doing that, I'm going to take a moment just to introduce myself. My name is Danielle Roberts. I am a Superior Court Judge for the Flint Judicial Circuit in Georgia. I flew here just to be a part of today's round. I do appreciate Justin and the Empire family for having me. It is a pleasure. This is not my first round with this case, but I will say that these two teams are here because you are the best of the best. That's how you made it to the championship round, and I can see why. I was extremely impressed with both the plaintiff and the defense team, from the witness performances to the attorneys and how you dealt with the objections. I intentionally did not use any of the pre-prepared questions because I assume that by this portion of the competition, you've heard them already and you were prepared to use them. and it didn't faze you. You continue to show and demonstrate a very in-depth knowledge of the case law and the material in front of you. I was extremely impressed with both teams. I wish you both the best of luck, and your parents, and you all should be very proud of the performance.
Thank you. Thank you so much.
Of course, I think we owe our presiding judge a round of applause. To do it this time because it takes a few minutes to get all the results, and we want everyone to stay calm and take some deep breaths. Why don't you take a break, go out, get some water, use the restroom, come back in a few minutes.
I hope I gave y'all enough time to.
Oh.
No, no, no.
We're doing this record. Do this record.
Okay.
I'm fine. You gotta do it.
We can have everyone return to their seats, please. You can trust the process to make the announcement. Can you let me know when your team is done? Judges and jurors, we have two incredibly talented teams today. We have teams that have been incredibly successful, both in their own state and the empire. Representing the plaintiff today, the Henrico Division champions, Henrico High School. Henrico High School won their division last year, and they are here once again in this round, which is an incredible accomplishment.
State, can I ask?
Virginia, the Commonwealth,
I don't get
the Commonwealth. Said from a Virginia resident. And then representing the defense, Trinity Pacific School from California. Let's give them a round of applause. These two teams won a combined 22 ballots. 22 ballots over this competition. An absolutely extraordinary number. An incredible accomplishment by them both. Announcing the winner can be bittersweet, because you are both tremendous. By a count of 7-2, our 2023 world champion, Trinity Pacific.
Everybody, let's give a round of applause for our runner-up, Henrico High School. Really, just unbelievable.
And at this time, we're going to have each of our teams take a photo with our judge, Judge